Are we allowed to petition?
My lord, that one line that as I was mentioning that it will not act as a precedent for other cases.
The peculiar facts of the case I have written.
Much
It
better.
is written. Item 2.
I've dismissed the petition, but I expedited the trial. All the three petitions. Yes. Mentioning? No mentioning. No mention. No. Item 1.
On behalf of Mr. Virat Dalai, item 52, kindly pray for an adjournment, Lordship.
After notice, a fresh matter. 52.
After notice.
After notice, then you have to wait.
After
Your question for orders, my lord.
For order.
Orders. Removal
No,
of
no.
defect.
Put a tick mark, we'll see. Yes, next.
Item number 53, madam.
50?
53.
Now,
1 week's afternoon.
fresh matter. 52.
Those are for removal of defects. They have not removed it. That's why those are.
Put a mark, come at the. Yes.
Your lordship. Item number 8
Eight, wait, it will come within some. What is
and 44.
44?
Adjournment.
44 adjourned. Why 44? What is the? No, 44. For orders again. We don't know. 44 mark is required. 8 we mark is required. We'll check. Yes. Come on. Yes.
32.
32.
Pardon,
Bail.
my lord, pardon to mention and mentioning out of list. My lord, the CRLMC number 4564 of 2024. My lord, the FIR is of 2013. Investigation is yet to conclude. This is a DA case. My lord, I have filed for quashing.
Give the.
Oh, please.
How many bail matters? 11. Okay. Come on.
32.
32.
May I please, your lord?
Yes.
Petitioner is the husband, he is the sole accused, is in custody, my lord, 13/6/23. And charge sheet submitted, my lord, 498A, 306, 304B by 34, 4DP.
Your husband.
I am sole accused.
So liquid.
The wife committed suicide, my lord, bolting inside from the door, my lord.
There is no suicide note.
No. That is the charge sheet.
Grant.
Obliged.
You tell me when you are in custody since
13/6/23.
13/6/23. Charge sheet file on
Charge sheet filed on
My lord, 9/10/23.
9/10.
9/10/23.
My objection, my lord, regarding doubt torture may kindly be noted. I objected.
Proraj, opposing the plea of bail of the petitioner submits that there are serious allegations regarding the torture for want of food.
Doubt.
Obliged.
33.
Uh,
34.
Please, your lordship. My lord, here the petitioner is in custody since last, my lord, 27/11/2023. And in the meantime, in this case, charge sheet has been filed under section 498A306, my lord. And charge sheet was filed on dated 26/1/2024. And the
You are the
present.
sole accused.
Yes, no. Here, my lord, the present petitioner is the husband, my lord, and also allegation against the in-laws, my lord. That was demand of.
In-laws, the bail, have you moved in-laws? They are arrested or anticipated bail?
They have not yet been arrested, my lord. So the present petitioner was arrested
You are in
and
custody since
custody since, my lord, 27/11/2023.
23.
And
Any
cause of
suicide note,
death,
anything?
That cause of death, my lord, similar asphyxia
asphyxia due to hanging.
Bolted from inside or what?
My lord, the
Yes, my lord,
antepartum-
that is-
antepartum, my lord.
Just check that.
That is reflected in the charge.
Asphyxia due to hanging, my lord, suicidal.
Appreciate. चलो सेम प्रोडक्ट जो लास्ट में लिखी ना क्या करके बिल्ड
Same objection.
सेम ऑब्जेक्ट यस
35.
ମାଇନର ବେଲଜମ କୋର୍ଟର ମ୍ୟାଟର ରହିଗଲା ଆଇଟମ 15 ବେଲଜମ ମ୍ୟାଟର ରହିଗଲା ଆଇଟମ 15 ମାଇନର
Wait, bail application fast niya hochi.
wait till your turn comes. You can't jump inside the proceeding and ask. ये तो one करो. Yes. Next
35.
35. Pass on.
36. 36.
Pass on.
37. May I please, Your Lordship?
My lord, here charge sheet under 376(3) and 6 books notice to go.
Notice.
Notice to go, my lordships, this petitioner is inside custody and he is suffering, my lord. So report may be called for from the jail, my lord, because he is seriously suffering.
What happened?
Some his blood is exchanging, my lord, but they are not supplying the
Get the
information.
report also. Mr. The consular petitioner submit that the petitioner accused is seriously ill, and the report should be called from the suspension jail. Mr. Proraj, it's time to call for report. Log with your next picture is that of
My lord, otherwise, it's a notice to go, my lord.
Notice today I will serve.
Notice
notice to the.
CDL.
No,
Course of the day I will
if
serve.
he is terminally ill, then we will think of granting interim bail. Interim bail and.
Course of the day I will serve the copy, my lord.
If blood transfusion and all something.
Let it file a IA, my lord, so that it will be.
You file an IA, bring all this thing on record.
Because,
Interim bail you can one.
They will not supply, my lord, because he is in custody. So
I am asking of you move an application,
Yes.
narrating whatever is there. Whatever health issues are there, you
My
narrate so
lord,
that we can grant you interim bail, at least you come forward.
God bless. 38.
20B2C, in this case, charge sheet submitted without the C report. And,
Without C report,
yes, madam. And
recovery,
recovery, my lord,
capture
in
from the
front,
spot, my lord.
take 1 minute. Front of the
516
house of one Trimula Honta, that is reflected in page 10 of the FIR. Allegation that the present petitioner was there at the
in that house.
in front of their house.
In
Barandaru siege hela,
same place where the, my lord, seizure was.
and the C report not submitted. I have given
What
the,
about the C report?
I have given the order, my lord, kind of a glance.
Get this.
Latest order, my lord, I am awaiting the C report. The
My lord, then we have to move
No, what?
for the court in session, my lord.
a default bail can be raised in the bail application also.
You are correct.
Now, have you taken this point there in before trial court?
No, my lord, that is not there.
Where is that? Where rejection order? Just see.
The rejection was before the submission of the charge sheet.
There.
Before the submission.
Yes,
Like write down the learned the bail plea of the petitioner was rejected on 21/7/2023 by the learned court below. Whereas the charge sheet was laid down on
On 5/12/2023.
5/12/2023. Let consider the petitioner relying upon a proceeding dated 11/1/2024 submits that in the charge sheet the chemical examination report has not been filed. Therefore, he seeks to withdraw the present petition so as to apply a fresh before the court below for grant of bail. With this liberty, the petition is disposed of. You show it and you get the bail. That's the constant order.
My lord,
That's the regular order. You will get it. I have recorded. Move it immediately.
Yes.
Dispose of,
Yes.
with this observation. Yes.
39.
My lord, 41 here during the course of investigation he has come. Let him come after the.
Wait,
My lord.
but let counsel for the petitioner seeks to withdraw this petition
Right.
to renew his bail plea after the charge sheet is laid down.
Man, hopeless.
Please put up with this subject.
Jury report was called for, my lord. Allegation is that. Sorry, 40.
40. ଆପଣଙ୍କର
41.
okay 40 pass ହବ from 41.
41.
Maybe. My injury report was called for. Allegation is that, my lord, so far as the petitioner are concerned,
Hmm.
the informant,
My lord, here, my lord, investigation is continuing. They have
No,
not given
the-
the analysis report, my lord. Since the both.
Right. so far as the,
Since
Wait,
you are submitting, injury report has called for. My lord, injury report has called for because, my lord, nature of injury is shown, my lord, bomb injury, and one person have lost his leg, my lord. That's why, my lord, they have not given the injury. Your lordship may give us some time. I'll get among
Get
the injury report so that.
Because
so far as the petitioner is concerned.
one injured has
No. So far as
Leg is-
those who are throwing bombs, my lord, they are not before your lordship. The petition number 1, Ajay
1,
Das,
2, 3, 4.
3, 4 not named in the affair. So far as Ajay is concerned, my lord, petition number 1, as per affair story, my lord, he has given a slap, my lord.
Let it come yes. Wednesday, Thursday. No? जो 10 meter you get the report.
Yes,
right?
sir.
Yeah? Individually will
I get.
analyze.
Lord.
Why have you
Okay.
filed common bail application for all 4? You
ତଳେ
should have
ଆଜ୍ଞା ଯାହା
separate-
ଫାଇଲ କରିଥିଲେ ସେ ଅନୁସାରେ
separate file you should have.
ମୁଁ କହିଥିଲି ସେପାରେଟ କରିବାକୁ ସେମାନେ ଆଜ୍ଞା ତଳ କୋର୍ଟରେ ଆପଣ ଜାଣିଛନ୍ତି
Because if one accused is stuck, then other people.
14.
Yes.
We have to be, reflection of that. Individually, you have to tell me.
Right.
All the 4 accused, what are the allegation? You get ready and come.
yes
You will see corresponding injuries there or not.
Yes.
Once he spoke, statement has been recorded specifically, when role has
Then
been
show me
described.
that.
Yes.
Okay.
42.
Yes. Pass
What?
over.
43.
Yes. Pass over.
Item 3.
Okay. It matters.
The petitioner hearing
Yes.
file this application praying to pause the proceeding against the present petitioner is concerned.
Hmm.
The complaint lodged by the opposite part number 2 before the land magistrate below, the land magistrate has taken cognizance of the offence against the present petitioner as well as some others.
Hmm.
Under section 406, 420, 120B, 294, 506 of 34 IPC.
Yes.
The complaint allegation is that the lordship would find the complaint petition. I have annexed that is that page
Lord,
76.
My lord, I think, my lord, yesterday similar matter was there. my
Yes,
lord.
yes.
My lord, that has been posted to some other day. My lord, your lordship may kindly call this matter along with that case, my lord.
Which one?
There, my lord, the
That
information was
was
also appearing.
that is
Informant?
4155 of 2023.
Yes, my lord.
4155 of 2022. Do the like this, then look at it.
My lord, I have filed an IA that
I don't know whether in that matter have I passed.
No,
any-
yes, no order. was
order
passed.
was passed, but here it is case quite different from the petition in that case. Though arising
When is that matter? You say?
4155.
415523.
Kali.
First May. These are the same same complaint.
Out of same complaint, but
That
the
has to be analogously heard.
but the allegation against the present petitioner concerned, I'll
That has to be seen, my lord.
That has to be seen individually because
My lord,
it's
my lord,
state of cognizance only.
warrant has been issued, available warrant.
Go and I'll say it. Go and available warrant.
Yes, ma'am.
What is the great deal? Go and appear. Go and appear. May.
And appearance of the early date may be fixed because your lordship kindly have a glance to the allegation part only one paragraph.
Right, but see, these are at the stage of cognizance.
Yes, Cognizance and 205 application filed by the present has been rejected.
Yes, my lord. Sole grievance is the two zero
That is
five.
the whole idea.
But that
Yes.
was not there in the prayer.
You are not, your intention is not for quashing, your intention only to avoid the proceeding.
No, my
You
lord.
the two
No, my lord.
five rejected, therefore, you file a 482 for quashing.
Your lordship, just for a moment, kindly see page 80.
You tell me, if I allow your 205, we will be happy?
Yes, madam.
I was asking the same thing. You,
If-
for
if-
205, you have come here.
But the allegation against the president, I want to show
See,
the page 80. Your lordship, for a moment, kindly see
Yes,
the
yes.
allegation.
Yes. Why-
Page 80,
80,
80, page 80, annexure 4, running page 80,
yes.
para C, my lord. Para C, middle,
8,
B and C, page 80.
yes.
Para C, that the complainants company has also learned that the said legal heirs of Durga Pradhan and Bhattokrishna Pradhan have also fraudulently entered into agreement to sale of different parts of said plot number 1180 in favor of 3 other persons, namely Sitar Prasad Das, Raj Ranjan Beura and Fakir Mohan Das. The Sital Prasad Das and Raj Ranjan Beura have only entered into an agreement for sale.
You are the.
I am for them. And neither any registered sale deed has been executed in their favor by their vendors.
We are going in that direction. Sale bearing number.
So only allegation is this.
That has to be seen.
When you get the bail, what is the problem?
Yes.
You appear and get the bail. If this is the allegation, any court will give you bail. What is the big deal?
Well,
Why 205 then?
So I
Appear
yes.
and seek for bail, and then
with-
I will consider it. If no, nothing is made out, then we will see.
Your lordship, with that direction, I will appear and
In 482, how can I give? See, try to understand the limitation of this court also.
I
You have
understand.
challenged the cognizance order at this stage.
Entire proceeding. I prayed for watching of the proceeding against the present petitioner concern.
Right, that's right.
Because
But
no
it
prior
has a
basis-
cascading effect. Because see, so many accused are involved. One matter is pending. If I in between I quash something, it will have an impact in the other cases also.
In other cases,
And without hearing the complainant, it is arising out of complaint case. How can I quash or how can I?
lordship is
I'll issue notice returnable on that day. Issue notice only.
earlier date may you can fix.
We will see.
Because
That matter has to also vote.
some other matters, your lordship has fixed the date to earlier date.
Same.
See, arising out of same complaint.
Give me that date.
I am giving.
You give that date, we will release
Yes.
issue notice and the date whichever he is giving.
Sorry.
Latest date which is there.
Yes, yes,
So
yes.
that on that day I will
Yes,
fix it. What is it?
I'll furnish.
Oh, no problem. Do it.
Obligation.
Item 4.
Issue notice and file the requisites.
Yes,
I'll complain it has to be there.
today itself I'll.
Yes.
Item 4.
Pass over.
Item 5.
4.
And the joint affidavit, my lord.
Okay. Parties are there.
No, madam.
Then?
But it is not there, my lord. The deposit to the lady has already been married, my lord, the second
They
time.
have to
No,
come.
parties has to be there. Quashing petition, the parties are not there. You bring some affidavit
376 allegation is there.
and you bring the party. Okay. Bring the
yes.
party so that we can. You tell me the date.
Copy of the affidavit.
Yeah, no, sir.
Give you a copy to him.
Yes.
Bring the party.
Another date. madam.
Tomorrow they will make allegation against you and her.
Yes, yes.
We don't know somebody has
Appeared on
filed the affidavit. All these
Yes,
things will
madam,
happen.
right.
So therefore bring them.
the April first week, madam.
Hmm?
April first week.
April 1st week. It is passed over, sir. When it will come.
I will another pair, my lord. Lower court date has been fixed to 15th, my lord. Order was given to the
Nothing will happen. Yes.
Item 6.
Five. Huh? No, that was 4, item 4. That was item 4. 5.
Yes. May I please, Your Honor.
Lordship, I filed the petition under section 482 CRPC for quashing of the cognizance order passed by the Lord SDM Burger. The fact of the case, you know, the petitioner has kept a signed check in his scooty
Sorry.
on 14/4/2023. signed check.
Use mic.
Yes.
Yes. Yes.
And he has signed on the blank check, but he has not written the date of the, he has not written the date.
You are accused.
Yes, yes, in the,
You are the accused in the 1cc case.
in the one.
You had issued the check.
Your Lordship, in the 1cc check, in the complaint case, he has given another name, but my name is not mentioned, but in the notice has given to me to appear such and such. Kindly refer.
Let's see. You are Mr. Haradan Sahu.
Haradan Sahu.
Yes.
But name and address of the complainant, Ketuki Givela, is about such and such. And name and address of the.
Haradan Sahu, just see, come to page, what is this?
Yes, name and address.
Annexure 4.
Yes, Lord, sir. Name and address of the accused, Govardhan Judai, son of late Sundar Judai,
No, you come to Annexure 4.
and it's 4 years, please.
Certified copy of ICC case number 34 of
Yes, Lord.
23. Who is the accused? Haradan Sahu.
No.
It is written. Why you are saying no? This is exactly in front of me. Just see the complaint case. That's what I'm saying. Just see.
He has filed a complaint case against the Govardhan Judai, but notice is given in Haradan, in the name of Haradan Sahu. As
Where
per-
is the notice?
I have filed the notice.
Notice is Haradan Sahu.
Yes, yes.
Annexure 2.
Yes, notice is
Haradan Sahu.
copy of notice to petitioner, page 21.
Come to page 8, sir.
8.
First. Somewhere some spelling mistake, then you come filing 80 for it. 80.
Page 8.
8 is the statutory notice. Just see what is the name.
Yes, notice is given to Haradan Sahu.
Haradan Sahu. Okay.
Yes.
Now come to the complaint. Annexure 4.
And
It is
it's
Haradan Sahu.
no.
Why
Here-
are
here-
you saying no? Just see. Statutory notice is Haradan Sahu and complaint is Haradan Sahu.
No. Complainant is the Ketogi Givela versus of Haradan Sahu. As per the JRC of volume, criminal volume 1, it is not maintainable. Here name and address of the accused, Govardhan Judai, son of late Sundar Judai. Kindly refer name, address of the accused.
You are not clear what you are trying to convey. I am not able to follow. But the record, I saw the record. As per the record, it is in a 138 case. There are 2 stages. One, the notice.
Yes.
Second, the complaint. Thereafter, the
Yes.
proceedings are. The
In the-
notice is given to Haradan Sahu
Yes.
and complaint is also filed by Haradan Sahu.
No.
As simple as that.
Complaint petition is filed against the Govardhan Judai, not Haradan Sahu.
What is this annexure 4 then?
Yes, annexure 4. Kindly refer page.
Annexure 4. You have filed annexure 4.
Yes, I have filed.
That's the complaint case. Complaint case under 138.
Yes, annexure.
You have filed some. Are you in the
No.
same matter then?
Listen, let me allow say, Lord.
Yes.
Kindly refer page annexure 4, page 16.
At the top, annexure 4 at the top, just see. 1cg case.
Yes.
At the top, call title.
Annexure 4.
Ketki Givala,
Givela
the complainant,
versus
and Haradan Sahu is the accused.
Here it is written Haradan Sahu. But in the complaint petition, kindly refer that is the
Just show me.
that is the order sheet. Your Lordship is referring the order sheet. Kindly refer page 16. Ketoki Givela versus Haradan Sahu.
Again Haradan Sahu.
Yeah, written. But the here Haradan Sahu in the cost title.
There is some one typographical error for that
No.
you are coming. What are you talking?
No type. No, Lordship.
What is this? I have seen it now. Page 16 also I have seen it. Just the at the cost title. Again Haradan Sahu. Merely because in para 2 it is written Govardhan, the name and address of the accused Govardhan Sahu. Some copy paste has happened. You are making a grievance out of it. This is a matter of copy paste, small copy paste.
Your Lordship.
And every lawyer makes that mistake.
As per the
On that basis, do you want me to quash the entire?
as per the criminal volume 1, JRC of criminal, rule 20 says there is no title. There is no title. There is no title of the 1cc case. But here it will clearly mention the name and address of the accused. Name and address of the accused is Govardhan Judai, son of Sundar Judai. But notice even in the against the Haradan Sahu.
What is the check amount?
Check amount I have not filed. I have not obtained the copy.
What is the check amount of the?
Amount is
check
25
which you-
lakhs.
Huh?
25 lakhs.
25
written
lakhs.
25 lakhs.
There is no order of 143A so far?
Nowhere it is written.
I am not impressed by your arguments. What to do? Will you pay the amount installmentally or whatever?
No, you not
The
see.
check is issued by you. Are you denying it?
I have written my name in the blank check. I have not given the name.
So show me your reply to the notice.
This notice is page 10.
Yes.
Page 10. May I suggest, my lord?
Right.
Unnecessary time is taking. May I suggest?
Why the time I shall.
1 minute. 1 minute. You also may kindly issue notice to the complainant so that let the complainant come.
No case is made out even for notice.
At least notice to go. So complainant, let the complainant come.
Shall I issue notice?
Yes.
I need not. take
Unnecessarily
time.
taking time.
Issue notice. You are not
There is-
able to.
There is no provision in the law ICC that the,
Right, you are right.
of the writing of the
Sir,
cosmetic.
in the reply to the check also, you have said, you have not said anything. And merely because one in the complaint, one place there is a typographical error, you can't ask for quashing of the entire
Yes,
already.
exactly.
25 lakh rupees check you have issued. And in the reply to the statutory notice, you don't say anything.
Yes.
For the statute.
Forget about statutory. Do you want accept notice?
Notice ka jawab.
That much only I can
Yes,
give
yes,
at this stage.
That is sufficient.
Otherwise, it is a matter to be dismissed right away.
Right, right. Absolutely right.
We wasted 10 minutes for that. Anyway, I am issuing notice.
Yes.
Let us see. The idea of issuing notice is if he comes, you get ready to pay the money and
Yes.
finish it up.
Yes,
That's the idea of not to give you relief.
yes.
Because check was issued, you may be having some financial problem. Let us make some installment or something. That's what.
I have a blank check. I have not,
Reply.
given, I have not given.
Read
the
your
name of-
reply to the statutory
I have
notice.
not given the name.
Read your reply to the statutory notice. Presumption operates against you.
Also,
The
issue
check
notice.
was given to, issued by you.
Hello, kindly issue notice.
I have issued notice, no problem.
Item 6.
Yes.
Maybe let's. The petitioner will challenge the order of cognizance as well as special just cut out.
Yes.
On the two grounds, my lord. Because my lord, similar allegation, my lord.
Lord,
Another
before-
complaint
Where is
was.
the charge sheet?
My lord, before
I already
I
filed.
commit, my lord, before I want, my lord, you lordship may kindly see flag B that order passed in CRLMC 1295, my lord. There the specific that the very initiation of the proceeding was challenged before this honorable court, and this honorable court, my lord, one honorable chief justice, my lord, or while disposing the matter, my lord, directed the petitioner to agitate all the grievances before the learned court.
Why are you
without-
coming and?
No, my lord, what
And
happened?
he has not agitated.
My lord,
Exactly.
earlier, my lord, I approached this honorable court to passing of affair, my lord. At the time,
Thereafter,
no, no,
one-
no, at the time of
charge
hearing,
sheet
my
is
lord.
filed once.
No, no, at the time of hearing, my lord, the learned counsel may say, my charge sheet submitted. For which, my lord, I challenge the order of cognizance, my lord. That's a very good case, my lord.
Thereafter,
That's
the
a
order
case, my
may
lord.
cancel.
On similar allegation, my lord, two cases in five, two
You have a
cases.
good case, then at the charge stage, argue all these things, you will be discharged.
Because what happened, my lord, two cases is registered against me on similar allegation, my lord. That's where I come, my lord.
That's
And my
right.
lord, in.
But the same thing you argued at that stage also.
Both cases are pending in different court, my lord. This is the.
That what can you
And
do?
two courts are
Because
taking
both
cognizance in
both
same.
are different than the
My
level
lord,
is also
in
different.
similar allegation, two cases are registered and two cognizance taken, my lord, by different court, my lord. This is the problem, my lord.
But how many times
And
you
my-
come to 482 court, every stage, FIR is lost.
My lord, because my lord, they submitted, my lord, during hearing,
Cognizance is taken
no,
482.
my lord, during
My lord, may
during the
kindly
hearing,
see
they
that order.
submitted, charge sheet submitted.
My
For
lord,
which
yes,
I
my lord,
approach
may kindly see that order.
cognizance, my lord.
12495 will also may kindly see that.
Avail the liberty given to you by the coordinate bench
Yes,
at the appropriate stage in this stage at the stage of framing charges.
No, my lord,
You have an extensive hearing there. Why are you
because there is
inviting?
no
a
scope, my
similar-
lord, because my lord, at the time of framing charge, my lord, there is no scope, my lord. Because there are two cases, my lord, in two different court, my lord. This is the problem, my lord. That's we kindly see, my lord, annexed to two, my lord.
Since
Case with my lord, same inform, my lord, same inform, my lord, file a complaint before the SDGM court on similar allegation, again file a affair, my lord. before the police, my lord. And police has no power to investigate case of drugs and cosmetic act, my lord.
But all these things you have argued at
That's
that
this
stage
is
also.
this is a very good case for interview on
Unfortunately,
this Hon'Ble court, my lord. You kindly see, my lord.
So you try to appreciate. Unfortunately, there is an order of a coordinate bench. I can't, I am not appellate court. I can't sit over the appeal because you got some order, wrong, right, whatever. What to do?
Because my lord, at the time of hearing they submitted that charge to submitted, my lord. Then now the mine scope is, my lord. At time of cognizance,
Show me in this order where they say that. Nothing is there.
Let's kindly see the order, my lord. Order passed by the
submitted
Honorable Chief Justice, my lord.
filed in the meantime.
Case was my lord, adjourned, my lord. Subsequently, they submitted, charge sheet submitted.
Where is that?
Yes, my lord. Order passed in, my lord.
That para 2, my lord, the second phase.
1 to 9/5/2001.
Everything, same thing you have argued.
Yes, sir.
Let's kindly see the order. The order is submitted.
Single word here and
My lord,
there.
incident.
My lord, case was my lord, adjourned to another date. Subsequently, they submitted, charge sheet submitted. For which order was passed, my lord. Let's kindly see the entire order, my lord. Because my lord, there is no scope for me, my lord. Because the two cases are two different court, my lord.
Not on the same offense.
Yes, my lord, same offense, same occurrence, same transaction, my lord. Let's kindly see. Same transaction, my lord. And one evening, my lord.
In order to avoid, my lord.
No, my lord.
Initially, my lord, that a complaint case was filed under section 27 of the Dog and Cosmetic Act, my lord. Thereafter, it was found, my lord, your lordship, that is spurious drug, my lord, Fabiflu or something, my lord, which is very much essential for the, my lord, that COVID period, that medicine is very vital. They have, my lord, supplied the, my lord,
Point of law is involved, my lord.
That's why, my lord,
Section 30
police
says, police has no power, my lord, to investigate.
we can do it.
With you.
Yes, my lord.
I am absolutely with you. But what to do in the face of this order? You tell me. Can I ignore the order of a coordinate bench of same strength?
That's my disposal. I will raise this
That's
point.
what I'm saying.
That's him.
Learned counsel for the petitioner submits that earlier he had approached this court by filing CRLMC in number 1295 of 2021 at the stage of investigation. At the stage of investigation. The coordinate bench by the order dated 15/5/2023 disposed of the matter, giving the petitioner liberty to raise all the points at the appropriate stage of the trial. And now cognizance has been taken in this matter. Therefore, he seeks to withdraw this petition to raise all the points available to him before the trial court at the stage of framing up charges. With this liberty, the petition is disposed. So now you can argue all these points.
Yes,
Item 7.
Yes. Yes.
Quashing of affair.
Yes.
The petitioner is not named in the affair. On the same day, arising out of same incident.
Charge sheet is filed.
Well, that I will take instruction, my lord.
Name, not name in the FIR.
Not named.
Charge sheet is not filed. Why have you come then?
My lord, the police is searching for me. That's all.
Then you are there.
Not there.
He may go for the anticipatory.
No.
In grab of anticipatory, file this
In respect of the co-accused.
Sir, you are also appearing in this matter?
No, in respect of the co.
In this matter.
I have 8 cases in this matter, connected matter. The rest of connected matter I am filing.
8 cases?
Yes, 8 out of 8 cases, 2 cases already been disposed of by my Lord Justice Sankar Mishra.
Then it has to go that one.
It was hard before the earlier because this Justice Sabitri Ratha, the order was passed. Kindly see. The last order.
Achha, before appropriate bench.
With the permission of the Justice Registry, that was the order. That's what I have. That was the order.
That is how it came before me.
No, I have not, that file maybe endorsed, I don't know. So the endorsement was there or not, I don't know.
But couple of matters are pending before Justice Shashikant.
Justice Sankar Mishra, 2 cases already been disposed of. Out of 8 cases, I have filed 8 cases. Out of 8 cases, 2 cases already been disposed by Madam Justice.
Where are those orders?
That's order is with me.
Show me. Those are-
To my lord.
One, two, three, 4, 5, 6, 7.
A stranger will file petition to quiet the affair.
Yes, my lord.
A stranger is filing approaching this honorable court in the guise of 480 to quiet the affair. How a stranger is active for registration?
2021.
No more a stranger because the police is after him.
My learned senior,
That's what I am asking.
My lord, 2021 Supreme Court is
If
very.
your name is not there in the FIR, charge sheet is not filed, why are you coming to the court?
since police is searching.
So for that, 430 it is.
430.
No, for that, even if there is no material, this honorable court has quashed in respect to the co-accused.
I'll simply write the petitioner.
Here, my lord,
Name
we
is
got
not-
during the course of the investigation, we got some sort of materials against the petitioners, my lord.
But you have not filed the charge sheet.
Yes,
So
my
he
lord.
doesn't have locus standi to challenge this.
Investigation is going on, my lord. Investigation is going on, my lord.
In all the matters.
If they are apprehending them and go for, my
My
lord.
name is there, madam.
Oh,
My
438,
name is there.
Oh, there is no bar to file for it too.
Now let us see.
Go back.
What
In the
which is
grab
your
of 482,
petition?
you'll
My
find.
lord,
Which is your petition? Santosh Nair, your.
my petition is
Your
Santosh.
name is not there in the.
My
FIR.
lord, kindly have a glance to page 13.
But your name is not there.
This
Simply you
one.
said,
This
so
one.
you don't have a locus standi. Because unless the charge sheet is filed. If you have an apprehension, 438 is there.
My
Okay?
lord,
Yes.
even if,
His matter is. And what is your
2021.
matter?
my lord, my lord, I may
I
pardon.
have been implicated.
Let the state take instruction of the charge sheet is filed. Let it come next week. I will also take instruction and obtain the certified copy of the charge sheet is
You are
filed.
not
But
yet,
the police is searching for me. Even if not named
you
in
are not
the,
yet an accused.
Charge sheet will-
even if not named in the fact, since police is searching, there are decisions and authorities that the petitioner can file under section 482.
Whole difficulty is you
Ah.
always threaten with the decision. Where is the decision? Show me.
Yes.
Why
Let
are you
it come next week. I will show.
I have a decision. Go. Show me one decision.
I'll next week come.
My lord, the-
Friend may for the honorable court.
Two matter lost it. Out of 2 matter, I have given the 1 matter has been disposed by my lord Justice of Second District. In that respect.
In the same terms, I will dispose it up.
Which matter?
Your matter?
No,
Other matter?
that my matter is disposed of.
Or the
Yeah.
other
So
matters,
he has
I will
taken the
dispose it
information
up. See, this is at the investigating stage.
Yes.
Yes.
This court is not going to enter.
No, ma'am.
As simple as that.
And
My lord,
this one, my lord,
My lord, my
in
kindly
this
see the
case,
decision.
That is
my
what
lord-
Shashikant Mishra is
In
also.
this case, my lord, in this case, opposite party stated that he has no allegation against me. For that, my lord has disposed of that.
Whatever, investigation is
Here
still
is
going.
there, my lord. And the other man.
There are how many matters?
My
One,
lord, kindly bear with me. In this case, my lord, justice.
four,
My lord,
five.
in this case, my lord. Advocate, senior advocate, Vaidas has been appeared in this case. He has instructed to my lord, he is in difficulties. And take it some time, he will appear, my lord.
you be
Thank
sure whether you are asking for adjournment or you are.
Adjournment, if the matter will be heard, my matter, lordship, my matter has been.
All the aforementioned, sorry, all the aforementioned 8 matters, na? 7 matters are arising out of the same FIR. The FIR, the investigation is still going on. Charge sheet has not yet been filed. Therefore, these petitions are.
My lord, I may pardon.
In one matter.
Petitions are premature. However, at this stage, Mr. Porida seeks an adjournment for a week. Release the matter before the bench on next week to next week. Okay.
No,
And I'll
except 15 or 16. 16 not be available.
but see, charge sheet is filed, then you
Well,
have to
if one
challenge the
gets-
charge sheet, whatever.
My lord, in one case charge sheet filed, that has been disposed of also. One case charge sheet has been filed, my name is not there, that case also disposed of. I have stated by 2 cases disposed of.
Prepare a chart.
Yes, ma'am.
I need not send it back to any other court because it is the assigned court.
Yes.
So I'll decide it. Also, prepare a chart and
I don't have an objection. That was the order that I have.
My lord,
prepare a chart, I'll decide.
all the cases we will prepare chart. My lord, all the cases adjourn.
By that time, you will get locus also.
My lord?
By that time, you will get locus standi, because you will be an accused.
Yes, yes.
So my entry order will
This
be continued.
matter will be infructuous.
My entry order will be continued till next.
Madam, I may pardon.
All my 6 matters.
Madam-
All my 6 matters.
Wherever there is entry
Tin
model,
cast.
continue.
None suppose.
Wherever there is no entry model, no entry.
My lord, I may pardon. In my case, there is no interim order.
That's right.
My lord? I pray man interim order, no course.
I'll say the investigation then.
My lord?
I'll say the investigation.
No course action, not stay the
Why no
investigation.
course of action in the graph
What
of
is this
482?
in 482? You are asking all these things?
All the cases, my lord, adjourn.
Oh,
Yes.
simply it.
21st.
No, in my all 6 cases, entry order is there.
Wherever entry model is there, continue. Wherever it's not there, not there. Yes.
21st. my lord.
8.
Either way.
Lordship seeking for an adjournment to 12/3/2024 similar matter CRLMC number 4424 of 2023 my lord,
Listed on that day.
fixed for that day.
If you listed, then tag with that. Huh?
Oblige.
Number, you just give the number. Which number is that?
4424
Double
of 2023. 2023 CRLMC.
9.
Item 9.
On behalf of Ms. Sota, it may be taken up some other day.
Urgent.
Oblige.
Item 10.
10 and 11, I have to take instruction in this matter.
The Maharana seeks time to obtain instruction in this matter. Urgent 2. April 10 and 11.
10 and 11. Item 12.
Yes.
So last issue the notice the second. Within that. Passing of the proceedings.
Two, my lord.
You should notice. Notice not yet. Yes. What is this case?
I am appearing for a opposition two and filed an affidavit, my lord.
Settle.
Yes, my lord.
Yes.
Both are present.
Parties are there.
Yes, my lord.
Settle on which ground settle? That
Earlier they
498, eh?
this is not
Oh,
4.
376.
So far as merits of the case is concerned, I have prayed for passing the entire proceeding. On the ground, my lord, if you lordship will find from the entire case record, the point of law involves in this case is, Lord, I have given the 16 points I have raised in the 482 application. Number 1, my lord, is whether land court below has power to prepone the case and direct the police to investigate the matter. This is number 1. Number 2,
Prepone the case of what?
the case was posted to 21-9. Lord Magistrate Somoto urgent prepone the case to 12-9 and issue a direction to the IIC to register an FIR. This is number 1. Number 2, so far as 156.3 is concerned, my lord knows that the Priyanka Srivastava case, subsequently other case. Honorable Supreme Court has said before exercising power 156.3, compliance of 154.1 and 153 is mandatory.
And
In the-
155 also.
In the present case, there is no compliance of 154.1, 154.3.
Yes. Next.
Number 2. Number 3, the complainant itself, a struck up company on the date of registration, filing of the complaint petition, that company was struck up. Whether a struck up
At the time
company,
of commission of offense, it was there.
yes, at the time of commission of offense, company was existing. On the date of filing of the complaint petition,
Anyway,
company was struck up.
we have to issue notice.
Yes, 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 yes.
We issue notice.
Yes,
Let
ma'am.
us see. All
Yes.
these points, let us. If you have point, then
Only early date may be fixed so that,
he will fix it.
yes. In course of the day, I am filing the request.
File and bring them. What is the allegation against you?
But my lord knows non-refund of my amount. Is it a criminal offense? I will come to that.
Amount of how much?
There was an agreement for supply of iron ore fines. If I fail to supply the iron ore fines, can it be a criminal offense?
But you pay the money.
There is no outstanding at all. I have given the lords my books of accounts.
Oh, then shall I send you to?
Yes, after
mediation?
6 years.
I'll send you to mediation, let them come. Whatever money you must be there, because in this business, running bills are there. There must be a dispute regarding the money part. And you sit together and decide it.
No, Satan, no. Kindly, she has already, you lords, can page 98 of my brief.
98.
98 of my brief.
Yes.
First sentence.
I'm the managing director of Trustee.
No, 98, page 98, cross-examination, answer.
Yes, 98, yes.
8, answer 8.
I don't want to proceed further in this case.
Still then,
Then there is a chance of settlement.
on the other witnesses are not coming forward to adduce
There is a
evidence.
chance of settlement.
My lord,
There is a chance of settlement then.
whom?
Hey, you.
ସେଇଥିପାଇଁ କହିଲି ଆଜ୍ଞା ଆସୁ
You
notice
bring
ଦେବା।
them, we will send them. If they say that I don't want to proceed.
Many application is pending before this honorable court. One of the application is pending of this petitioner by CRMC number 6953 of 2020.
What is this?
I don't know.
What is this?
6953 of 2024 of this petitioner.
A petition case, a particular case.
Exactly particular case.
Okay.
Particular, because he search in the money every night he keep on searching things.
No, ମୁଁ certificate ଦେଇଛି। ମୁଁ certificate ଦେଇଛି।
ଆପଣ ଦେଇନାହାନ୍ତି, ଆପଣ client ଦେଇଛି।
Investment ସେଟା ହବ।
No.
Note it down.
Yes, I'll
Note it down. Because you know the other case, the client had not instructed you to move an application.
Exactly.
Same thing will happen.
Exact. CRLMC number 6953 of 2024.
Yes.
6953. Huh?
Of 2024.
Because on the basis of FIR,
wrong number, I think. Maybe ଆଜ୍ଞା ହବନି 6953 କେମିତି ହବ? 24 କେମିତି ହବ?
ଦେଖୁଛି କିନ୍ତୁ ନେଟ୍ ରେ ଦେଖୁଛି।
ଆରେ ଦେଖେଇବ କଣ ନେଟ୍ ରେ?
ଦେଖନ୍ତୁ FIR ସହିତ କନେକ୍ଟ କରି କରୁଛନ୍ତି। 23 କରନ୍ତୁ ତାକୁ ଦେଖନ୍ତୁ।
6 ହଁ I'll
23 କରି ଦେଖନ୍ତୁ।
23 ଦେଖିବି।
23 କରନ୍ତୁ। Maybe 24.
Yes, I'll check it out.
24 22 କରି ଦିଟା।
ହଁ ମୁଁ ଦେଖିଦେବି। ଦେଖିଦେବି। ଡାଇରୀ ନମ୍ବର ହେଇଥିବ, ଡାଇରୀ ନମ୍ବର ହେଇଥିବ। Diary number.
Maybe.
Diary number.
But that
let notice go, let them say, let them say.
Abundant caution.
Let them say.
Abundant caution.
Application is pending, I'm sure.
Because unfortunately, unfortunately, you have those kind of clients. So that is the reason he's
challenging the order dated 14/12/23 Milord, rejecting the application under section 457 of CRPC for release of vehicle, my lord, by the learned
release of
my lord, release of a scooty, my lord, a vehicle, my lord. Petitioner is the owner of the seized TVS Jupiter 125 vehicle, my lord, and the same has been seized in connection with a case under section 20B.
Why have you not filed a revision?
My lord,
revision also lies, no?
Also for it.
Anyway, what is the ground?
Vehicle is laying from the police station, Sadar Excise premises since 6/12/22, my lord. Charge sheet has already been submitted. I have annexed, my lord.
What is the reasoning of rejection?
The vehicle has been sit in view of the decisions of Sundar Bhai Amla Desai, my lord. Vehicle should not be written.
You are the owner?
Owner, my lord.
And accused?
Bail
application
is pending.
You are on bail?
Bail.
Yes, my lord.
Yes, Mr. Maharaj.
Yes.
Have you seen it? Come to page 13.
Yes.
Last 5-6 lines. Page 13, last 5-6.
Page 13. Yes, not mad because you lost him just.
There is nothing on record till date to presume that the accused petitioner is innocent. Rather, the release of the vehicle in his favor will give a scope to the accused petitioner to use the same also for the further transportation of the contraband articles.
Yes.
And these are the grounds.
Well, section 70, section 60, subsection 3 of NDPS Act is a bar. So far, release of vehicle is concerned because constitutional proceeding is started.
Started?
Yes.
In this case, not started.
That application, your lordship may kindly see of the NDPS Act, section 60 and
No,
subsection.
but where it doesn't say that confiscation proceeding is started.
No, my lord.
Nowhere it is said.
And this petition is the accused where he was himself transporting the ganja.
That's
Yes.
right, but confiscation, where is confiscation proceeding?
No, my lord, confiscation is not there.
Let issue notice to the opposite Mr. Maharaja accept notice. Notice. Mr. Maharaja states that confiscation proceedings has been initiated against the petitioner for in regard to the vehicle in the subject. He would be seeking instruction regarding the stage of the confiscation proceeding. Leave the matter, sir. Let him get the instruction.
Yes.
Yes. Next.
Item 15.
Just a minute.
I please, your lordship.
Section,
My lord.
section 3, any animals or connivance used in carrying any narcotic drugs or psychiatric substances or controlled substances or any article liable to confiscation under section 1 or subsection 2 shall be liable to confiscation unless the owner of the animal or connivance proves that it was so used without the knowledge
That's
or
right.
connivance.
You can proceed with them. No problem.
Yes.
You can confiscate.
Yes.
Proceeding in the absence of a confiscation proceeding under section 60.
Right.
457 is liable to be allowed.
Yes, yes. That
You,
I take
you initiate, then that's a different story.
Yes, yes.
Yes.
May I please, your lordship? My lord, badge of matter and below order number 09 2114 answer 1 page 10. My lord, session judge Hon'Ble of the CTS 137013. My lord, order Hon'Ble High Court of Orissa BLPL number 753/2010. Filed order number 4 31/3/2010 answer 1 page 18-19.
What is this? What is this case? 1515. NBW crossing of
Belgium.
When you were on bail,
Yes, madam.
give me the date of bail.
BLPL number 7/3/2010. Filed order number 4 31/3/2010 answer 1 page 18-19.
31
31/3/2010
31/3/2010
answer 1 page 18-19.
21/8/2014 21/8/2014 ठीक है. How many of them are there?
One, I guess.
One is there.
Yes.
And 30th, 1000. Yes, the NBW, I am quashing it.
Yes, madam.
And on or before 30th of March, you have to appear before court and seek your remedy.
Yes, madam.
And the cost of 1000 rupees is imposed on you
Yes,
for
madam.
coming to the court late. Okay.
Okay.
Item 16.
Me, please, your lordship.
Yes.
My lord, the petitioner approached before this honorable court for quashing of the criminal proceeding on the ground of compromise, lordship. My lord, the petitioner.
Where are they?
My lord,
What is the offense, by the way?
My lord, offense is 420, my lord.
420. Where are
And compound rule, my lord, and
Call them.
petitioner informant already received the amount, my lord.
Call them. If they are there, we will do it. What is the problem?
Informant.
My lord.
Where is the informant?
I am appearing on behalf of the informant. Informant is
Sukant
present,
Rao.
your lordship.
My lord.
Sukant Rao.
Yes.
And Prakash Chandra Behra. कौन ହେଇଥିଲା ଆପଣଙ୍କର? ଗୋଟେ ମିନିଟ କଣ ପାଇଁ କେସ୍ ଫାଇଲ କରିଥିଲେ ଆପଣ? କେତେ ହାଁ ଦେଇଦେବେ? କିଛି ପ୍ରୋବ୍ଲେମ ନାହିଁ, କ୍ୱାସ୍ କରିଦବା। କାହିଁ ନେଇଥିଲ ପଇସା? ଆଚ୍ଛା ଠିକ right up. At the instance of opposite party number 2, the FIR number so and so under section 420 was registered against the petitioner. ठीक है? Have you filed the affidavit? The petitioner and opposite party number 2 are present in the court. Same paragraph. ठीक है? They filed the opposite party number 2 has filed an affidavit. The parties have filed affidavit, separate affidavit, joint affidavit, dated 26/2/2024, inter alia stating that the dispute between them have already been settled. disputed amount has already been paid by the petitioner to the opposite party number 2 to his satisfaction. Therefore, the opposite party number 2 is not interested to prosecute the petitioner in the present case. Mr. Maharaja appears for the state and submits that the dispute is the inter se party, and since they have settled their dispute amicably outside court, there is no legal impediment in quashing the same.
Yes.
With quash. Yes.
Item 17.
ଆପଣ ଆଧାର କାର୍ଡ ଗୁଡା ଦେଇ
Aadhaar card de degi, xerox cross copy. But the petitioner is facing trial under section 376. In the matter, in the meantime,
हुआ petition कर दो चाहिए हुआ petition पता नहीं और काउंट के yes.
in the meantime, matter has been settled between the parties. The parents and the victim both have deposed before the court below. And in the
Call
meantime,
them, we'll do it.
my lord,
Call them.
I'll file court.
When? Tomorrow? Day after?
Only here I have filed for recalling of PWs 1 to 3.
It is a matrimonial dispute. Now the people,
No, not matrimonial. But the petitioner and the victim both were elopement with each other. During due to elopement, the victim had given birth to a child.
The victim is a minor.
Yes. Victim at the time of occurrence a minor, but now she is major. She is major, my lord. She is 18 years old.
Now maybe, but
the victim, now the victim is staying with the in-laws house with the accused. And there was a set.
Jadi saya hela, jetawale deposition hela, then why the
164 is there.
Deposition is also there.
And deposition, I want to recall that. And also I finally recall, and there was a settlement in the Samaj that now the.
What say settlement ro कौन मिलिबो कहला क्या गोटे मिनट कहले से सब देखौछन आपण.
Evidence has already come on record.
That's why I filed the recall petition. That's why recall be allowed.
हमें गोटे law टा decide करै पय बसे. It's not a case of consideration.
That's the problem.
गोटे दिनसटा बुझियो चेष्टा करंतु. This is a case where
we have all sympathy for you, but
my only recall
all coming in.
I pray my lord, the purpose will be solved. Recall may be allowed and सेटा रखंतु नि कोर्ट रे खाली मत फेरे दिन
सर के जानतो आगे सही जाय गले तापर अलाउ होबे कि न होबे सेटा क्या
नहीं recall certain
question is similar matter came up for hearing.
सेटा कथा
The question is whether the recall application could be allowed to give an opportunity to the witness to wriggle out of his or her statement already made in the court.
That is,
and
but
you have already said that we have settled the dispute, therefore recalling the witness. So how can the court be a party to that?
But the court will not be a party. I pray my lord one thing. I'll frame questionnaire.
And the girl will be prosecuted also if she will wriggle out under the law.
And that cannot be. She cannot be. In such way, she will give evidence that she will not in problem. The witness will be problem and accused will not be.
Societal approval and the legal issue. There are two issues.
Conflicting.
What to do?
Social issues and also legal issue. But
get some judgment. Help me so that I can. Get some judgment. You research and give
after
so that
recess,
we can help out.
Yes.
We have all the sympathy. He will also work for you.
ମୁଁ ସେଇଟା ଖାଲି କହୁଥିଲି
Work for you.
ଗୋଟେ bar ରହି ଯାଉଛି ନା.
There is a legal bar. That's the whole difficulty. How will you get out of it?
But the three, my lord knows the 311 at any stage the petition cannot be recalled for a just decision of the case, either for the prosecution or for the accused.
Get some judgment.
I'll give him. Let it come tomorrow. I'll give judgment.
Not tomorrow, maybe next week. First 2 days bail matters, na? Keep it on Monday, Tuesday. Come with some judgment.
I'll give some judgment.
Don't repeat the same thing.
No, my lord, I will give.
Only legal issue address.
Legal issue I will address.
ସେଟା ହେଲେ ବି ସମସ୍ତଙ୍କୁ ସାହାଯ୍ୟ କରା
That will be helpful to many other cases.
No, in 311 I will give judgment.
Get some.
If my lord will keep tomorrow, I will also give.
Don't tell me the general proposition.
Not general, but for the facts of this case, legal issue, but if the victim was minor,
Matching the facts of it.
matching the fact of the case.
Get some. Monday? Tuesday.
13.
13. 13, eh? 13.
Item 18.
Item 18.
Yes,
Item 18 can be taken 2 weeks after.
yes, urgent. I'll just come on. I'll just come.
The NDPS Act,
Hmm.
but their depositions I have annexed, but they're totally not cross-examined. Only one line has been put.
Show me, cross examine.
Page 22, my lord, kind of glance so far the PW1 is concerned. At the last paragraph 8.
Yes.
It is not a fact that I am deposing falsehood in this case being an officer. This is the only the cross-examination.
Why have you not done?
And now that conducting counsel, as I stated in the 311 petition, he was ill and the junior asked this question. Subsequently, case
PW1.
P2, 3, all have been said. PW2 my lord, kind of.
Who all are they? Who are they?
Page 24. Yes. That's the same line. It's not a fact I am deposing falsehood in this case being an officer. They are the
Who all are they?
members of the raiding party. They are the material witnesses. So far the NDPS Act is concerned. My senior also.
Absolutely right. Question
One
of
opportunity.
No, that I am always with the lordship's views. But sometimes I am extracting my opinion because of the conduct of the accused persons. Conduct of the accused persons.
What is the conduct?
One CLMC application by 3803 of 2023, which has been filed before this Hon'Ble Court. A reason order has been passed, giving the liberty to the accused person not to commit or not to avoid to appear before the trial court, and subject to correction, some fine perhaps has been given, 500 or something has been given. It has been disposed of. That 3803 of 2023. And what they did, when the case posted for trial, intentionally they avoided not to appear. So now warrant issued. Then they go on absconding, right, my lord? Then when they come again, after 2 years, they filed a application for bail job. That is your lordship. And this Hon'Ble Court, with a 1.5 page order, giving liberty to the person not to commit the similar type of offense and always appear before the trial. And by the time, in 2024, one of the advocate come up and he said that my client has engaged me, the previous counsel who has been engaged, he is not able to cross-examine properly. And I am here to cross-examine the accused.
Now they are serious to defend themselves.
And everything has been narrated by the trial court. Your Lordship may kindly see. These are the situation why they are filing this application in order to delay the proceeding. And in one way,
Not delay,
the proceeding will be-
one day your Lordship fixed a date. On that day, we will cross-examine all.
Let us see the
Page 16,
Yes,
the word starts from perusal. Peruse the
1 minute.
evidence,
One
last
minute.
para.
Let me see. Page 16.
Page 16.
Here is the evidences of PW 1, 2, and 3.
Yes.
They
Then-
got examined on 7/3/2022. Present accused Pramod Tandia and other accused Lobbo Jal are facing trial. The accused Pramod Tandia, though present on the date of occurrence of date of examination of PW 1, 2, and 3, did not file any petition through engaged counsel after closure of evidence or soon after in other dates that the above witnesses were not properly cross-examined. The prior petition of the accused Pramod Tandia in engaging the new counsel
After 2 years.
was filed on 17/1/20. They are the rustic
Meanwhile,
villagers.
you are absconding.
Not absconding.
NBW was
ତା
included.
ପୂର୍ବରୁ
Everything
ସେମାନେ
is
abscond କରିଥିଲେ ଯେମିତି ଅର୍ଡର ପାଇଗଲେ ହାଇକୋର୍ଟ ରୁ ସେମିତି ଗଲେ ସେଠି ଗୋଟେ ଚେଞ୍ଜ କଲେ ଓକିଲ ଚେଞ୍ଜ କରିଦେଲେ ସେଇ ଗ୍ରାଉଣ୍ଡ ଟା ନେଇଗଲେ ଯେ କେସ୍ ଟା ଆମେ ଚେଞ୍ଜ କରିଦେଇଛୁ ଆଉ ସିଏ ଭଲ
Belgium
ଏକ୍ସାମିନ
matter,
କରିନି
your lordship,
ଆମକୁ
that
ଚାନ୍ସ
is
ଦିଆଯାଉ
fault
examine
of the advocate matter, they did not take step.
and in order to fill up the lacuna of
No,
the
what he says that looking into your conduct, why indulgence
No,
should be
your
given?
lordship may.
You take the court
your lord-
proceedings so lightly,
No, madam. Only so far 3803 is concerned.
and
That Belgium
at your
matter.
sweet will come at your sweet
No,
will
only,
will go,
only.
and whenever you want, you move an application. What is this?
No, only one day your lordship fixed a date.
This is
On
only
that
difficult.
date, I will examine all the witnesses. That I undertake. Only one day I will examine all the witnesses without seeking seeking for time. One day I will
How many
examine.
witnesses have already been examined?
Already examined 9.
9.
Yes, madam. I have already cooperated till examination of the 9 witnesses. Subsequently, when the new counsel engaged, he found that we don't
Show me
want.
those orders.
I'm reading
Okay.
that, that has been clearly mentioned. Then for a second, PW 1, 2, 3 were cross-examined
By another advocate on behalf of the
page
local
17,
judge.
page 17, Lordship. By another engaged advocate on behalf of the accused Laba Jala, the previous engaged counsel of accused Pramod Tandia, being aware of the cross-examination of accused Laba
Jala.
Jala, by his engaged counsel only cross-examined to suit his defense, suggesting only put up to PW 1, 2, 3 by the previous engaged counsel of Pramod Tandia to witness after going through the cross-examination of above 3 witnesses. But what is important? After going through the cross-examination of above 3 witnesses, 2 years is going to be elapsed since the examination of PW 1, 2, 3. Right, Lordship, got it? 2 years back, PW 1, 2, 3 were examined in chief, cross-examined. Then in 2024, they filed an application changing the advocate, taking a plea that that advocate has not properly cross-examined. That is the whole difficulty with the IO and the informant yet to be examined. Only IO and informant is left to be examined.
Totally,
And in
madam,
such
9
circumstances,
witnesses have already been examined. So, but the 1, 2, 3,
only to leave that, otherwise nothing.
only one date, madam. So,
And how my lord, will go bend the jurisdiction that in order to cover the lacuna or the latches of the defense.
No, that is not. See, the fact of the matter is that he is not cross-examined.
Here,
Fact of the matter is the earlier lawyer was ill and all these things. But his conduct is.
He examined and cross-examined.
There is no
But
cross-examination.
some question, yes, that is
one line
even-
is there.
See, I'll tell you, see, the offenses are serious offenses.
Yes, yes.
Official witnesses, let them come. But
Yes.
the only thing is the conduct, how to balance the conduct.
Yes.
One day that I am submitting on the your lordship fixed a particular
I'll
day.
impose heavy
Yes,
cost
yes.
because of your
Yes.
conduct.
Yes.
If I allow the application, I must impose heavy cost because of your conduct. Some deterrent.
Yes. Yes.
Not that at your sweet will you move application whenever you want to come to the court, you will come to the court.
What happened?
LBWG should, and
Conducting
all these
counsel
things
who was
will not.
conducting the case.
You are an accused in a NDPS case.
Yes, madam.
And you have to diligently conduct the defense of your own.
Sir.
Show me these orders.
Yes.
How much cost will you pay and where the cost will be deposited into the cost to Because you have burdened the trial court and
No, till that happens, since my lord,
both, na?
nine witnesses have been examined,
Whatever.
I'll cooperate with the trial.
Whatever.
Only one day, my lord, some cost your lordship may impose. But one day I undertake that one day I will examine or
I
cross-examine.
am allowing it, don't worry. I am allowing, but
1, 2, 3.
only wondering the cost has to go to
Yes.
Orissa Bar High Court Association or
Welfare
both High
Welfare
Court,
fund.
both district court, because they are being burdened.
Yes, yes, sir.
It should go to them. This
Just
time-
it is our bhala.
Right. Right down. The petitioner had moved an application under section 311 CRPC seeking recalling of both the witnesses PW 1, 2, and 3. All the 3 witnesses are official witnesses. Perusal of the deposition of these 3 witnesses indicates that there was absolutely no cross-examination. Cross-examination is conducted by the defense. The ground of recalling of the application is that the petitioner's counsel was ill, therefore he could not.
One judgment I have got, my lord, after 17 days.
He could not cross-examine appropriately. Mr. Maharaja appear for the state submits that in view of the conduct of the accused person, no indulgence is called for in this matter. Earlier, the said petitioner accused avoided appearing in the court, as a result of which NBW was issued on 19/3/2023. He approached this court by filing CRLMC number 3803 of 2023, and the coordinate bench by the order dated 17/10/2023 was the NBW and directed him to appear before the court. The petitioner is employing all the tactics to prolong the trial. The application under section 311 CRPC is one such ploy employed by the petitioner to prolong the trial. Therefore, in the event any opportunity any further opportunity is given to the petitioner, stringent conditions should be imposed on him on 2 counts. First, two count, stringent condition to be imposed. Taking into consideration the fact that the petitioner has indeed not appropriately cross-examined these 3 official witnesses, I am of the considered view that the petitioner should get a singular opportunity to cross-examine these 3 witnesses. Accordingly, the trial court is directed to recall PW 1, 2, and 3 on a fixed date and afford an opportunity to the petitioner to cross-examine the witnesses in the same day. Since the petitioner has successfully prolonged the trial by employing different ploys, he needs to be saddled with a cost of ₹5,000 to be deposited with the bar association, both district bar association, subject to the aforementioned condition. The petition is allowed and direction is
Yes.
5,000 you pay there.
Yes, sir.
Item 20.
May I please, lords?
Yes.
For this proceeding under section 107 is service order annexed 2 has been challenged, lords. It's only simply question of law. The before your lordship 107 111 has to be complied with. That is once has also been held by this input on annex 1. Then also I am pressing so far the 111 is concerned.
What is this order annexed 1?
That is annexed 1 also what happened 111. In the earlier occasion also same executive magistrate was issued a notice on section 107 against me, your lordship, and that has been challenged before this court because 111 has not been complied with by the executive magistrate while issuing 107. So according to this honorable court, your lordship, after being prima facie satisfying the case of myself, was that 107 proceeding.
Sir.
And stated given observation the last in the said order.
However, the quashment of
Yes,
the
however, quashment the so cause notice would not
preclude
preclude the state to give
give
proper notice in the episode if the apprehension so survives. So it was your lordship in the
Now
year of
notice is given.
2022
Notice has
year.
been given.
That's I'm coming. Now it is a case of lordship 2022 year. Then lordship again same mistake has been occurred by the same executive magistrate issuing another 107 case of lordship. That is a lordship 17 by 2024 under annex of 2 year lordship.
This is same Niranjan Naik.
Yes, same Niranjan Naik lordship. Lordship at glance 111 CRP first lordship. When a magistrate acting under section 107, section 108, section 105.
Where are you reading?
111 CRP books lordship. Yes, madam.
Yes.
111 service order to be made. When a magistrate
One
acting.
minute, sir. 1 minute. Sure. 1 minute. Yes, let me go to that. Yes. When a
magistrate acting under section 107, section 108, section 109,
And
or
10.
section 110 deems it necessary to require any person to show cause under such section, he shall make an order in writing setting forth the substance of the information received, the amount of the bond to be executed, the term for which it is to be enforced, and the number, character, and class, if.
Security, if any required.
Yes, my lord. Then, lordship, the notice 107, lordship, a glance, lordship.
Where is that?
Page 14.
Yes.
Annex 2, lordship.
Yes.
First party Niranjan Naik, second Naik Baba alias Vishwaranjan Pradhan, lordship. Whereas I am satisfied from the report submitted by the IAS in Waga PS by his non-affair number 96 dated 15/12/2022, that a disturbance created by the second party with the first party due to ill feeling between both the party regarding previous grudge, enmity due to party fraction, as a result of which there is a apprehension of imminent breach of peace within the local jurisdiction. I see so and so. Hereby do maintain peace and locality. They are also directed to appear in my court on dated such and such and to file so cause. Why would not order to execute a bond with security, good behavior and to keep peace in the locality. So 111 CRP status lordship, sum and substance of the allegation has to be supplied to me when this notice has been issued. That has not been there. Second thing, your lordship, 111.
This is the format followed.
This is the format. This is the procedure.
No, that already been decided our own High Court once, your lordship. In passing a judgment, I annexed your lordship. The 111 has to be complied, your lordship. That is not a format, your lordship. Why your lordship submitting? বইটা গলা যে মারছে কিন্তু হেরি সে বইটা গলা নেই সেন্স চেঞ্জ করলো নাই না now let's have a glance. So far the previous order passed by this court, there the order hold that 111 has to be complied with.
That's what the liberty is given to them.
Yes, my lord. So that liberty 111 has not been complied. Your lordship have a glance. What is the substance? The 91, 71 Supreme Court of Lordship 927 Supreme Court interpret that a substance means there must be essence of information copy has to be supplied to me, your lordship. That is not there, your lordship. And then also a glance.
Everything is given in this.
No, your lordship, no, that has not been complied with. Real lordship 111 will be read with together 107.
The parties regarding the previous girls and enmity due to the party. What is this written?
Fraction.
Party fraction.
Yes.
And tapare kono achi time and unit or something. Crusher unit.
This is not the substance.
Crusher unit. And what you need?
Lordship, this is not the substance.
Shall not be given.
Lordship glance. The substance.
Read 111.
Yes, my lord. I am reading, your lordship.
Once again read.
Yes, my lord.
Setting forth the substance of the information. It is not required. Succinctly describe the.
Describe, yes.
that is necessary, Lordship. Your Lordship have a glance. Your
Provision doesn't say that.
you know, yes, that is correct, Your Lordship. You will have a glance. Again, I am reading.
And he has read.
When a magistrate acting under section
Enmity
107.
due to party fraction and because of the cross
But
use.
I have to know, Your Lordship, that then other provisions that I am coming. The 111 is not only enough, this, Your Lordship, then I am coming other provision. 111 is like this, Your Lordship. When a magistrate acting under section 107, section 108 and section 109. Now, Your Lordship, the notice is under section 107, Your Lordship. Then also, or section 110, deems it necessary to require any person to show cause under such section, he shall make an order in writing, setting for the substance of the information received,
Right.
the amount of the bond to be executed. Where is the amount of the bond to be executed? That is not there, Your Lordship. Then the term for which it is to be enforced, that is not there, Your Lordship. And the number, character, and class of sureties, that is also not there, Your Lordship. If Your Lordship, by virtue of this, I appear before the executive magistrate, and suddenly the executive magistrate say you have to furnish surety, you have to furnish bond in certain kind of amounts, and that is not been ready with me. Then how I feel not the same, Your Lordship.
So cause as to why this is a so cause.
Yes, my lord.
This is a so cause.
Yes, my lord.
Under
Then a description order will be
under
passed
section
after
107.
107, 108, 109, 110. All these, Your Lordship, procedural, Lordship. If Your Lordship, a magistrate desire to be issued notice under section 107, 108, 110, 108, such and such, Your Lordship. Then while issuing so cause notice, Your Lordship, he has to describe in the so cause notice, Your Lordship, the language very much displayed in the act. That is, what is the amount of the bond, what kind of the security I have to furnish, so that I am ready go to appear before the executive master and execute the same, Your Lordship. That is not there, Your Lordship.
This is a notice under 107.
से कौन आसे से सिचुएशन आसे नहीं से कहेंगे order.
How, Your Lordship, you say that the situation has not been came, Your Lordship.
Here at the top.
Your Lordship, the
Criminal
11
Miss Case 17 of 2024.
good
Proceeding
word
107. It is a so cause notice.
खाली
Thereafter, it will, 111 will follow subsequently.
Yes, exactly.
That, Your Lordship, I am coming. I am coming some judgment law, Your Lordship. Your Lordship, I am not.
It is not 111.
It question ଅଛି.
No, it is not 111 CRPC. It is CRPC also 107 of CRPC. But 107 CRPC say the Lordship, 111 say that the Lordship, if you wanted to issue notice also 107 of CRPC, then you have to comply to 111. That is why, Your Lordship, the order passed by this earlier application, Lordship. That is in criminal miscase, I honest. That is criminal miscase 8258/2022. And the very language is there, Lordship. Peruse that is page 13. Peruse the notice of so cause which shows same is not in consonant with section 111 of CRPC. So 111 CRPC, Lordship said, Your Lordship, if you desire to issue notice on 107, Your Lordship, then 111 has to be complied with.
You have a point because you have a point only because according to me, for 107 notice, 111 is not required. That's not second stage. But the problem with prosecution today is page 13.
Yes.
Come to page 13.
Yes.
Para 4. How to get out of it? It
Yes,
says
my lord.
perusal of the so cause notice, and which is the same. At that point in time, you gave 107 notice. He challenged that notice, and he argued the same thing.
Yes.
When he argued the same thing, the coordinate bench says that in order to 107, you have to follow 111. And today you repeated the same thing. But this order was, according to me, I am not agreeing with the coordinate bench.
Exactly.
I am not agreeing with the coordinate bench. But the coordinate bench with the same strength, I can't ignore.
Unless until yes.
Let's have a glance.
That's the correct interpretation.
No, Your Lordship. No, so cause, Your Lordship, so cause is another part, Your
I will
Lordship.
issue notice because of this.
Yes, Lordship.
I am telling you, this is the.
No, I will satisfy, Lordship. With the judgment, I will satisfy,
Maybe
Lordship.
correct.
Yes,
Okay.
correct. Yes, Lord.
But at the same time,
Say order only because of that order.
because that's paragraph.
Yes, that order. But actually, that is not the.
You should have challenged this order. Why have you not challenged?
ये तो आपको दीप एड्रेस ये चैलेंज करेगा था. It's an individual party.
The earlier,
No,
the earlier occasion.
Your Lordship is issuing
Earlier,
notice.
1 minute. I understood it. Now nothing to further elaborate. Let us hear the other side. On the earlier occasion, the petitioner approach this court by filing CRLMC 825 or 2022 after questioning the notice he has received under section 107 CRP. The coordinate bench by order dated 12/8/2022 set aside the said notice inter alia stating paraphrase. Pursuant to the order of the coordinate bench, the executive magistrate repeated another notice under 107, which is at annexure 2. At annexure 2. Okay. नहीं डेट लिख दियो right? Another 107 notice dated 12/2/2024, which is annexure 2. Annexure 2.
That is criminal miscase 17/2014.
Yes, Mr. Mohanty appears for the petitioner, submits.
Mr. Jana. Yeah.
Oh, sorry, I'm so sorry. Jana appears for the. I'm extremely sorry. Jana appearing for the petitioner submits that the notice is directly in violation of the earlier order of the coordinate bench. Directly because the executive magistrate has not complied the requirement of section 111 of CRP. Issue notice to the opposite party, returnable within 2 weeks. In the meantime,
Stay for the proceeding.
In the meantime, the proceeding.
Yes.
Fairly,
I am submitting one thing. My Lord and friend and myself was the junior of Justice Rajkishore Naik, advocate, senior advocate. And both we are arguing some point of law before another coordinated bench. And so far 111, 107, he is supporting me by that time. Now the other side is now opposing me.
That's what I'm saying. He changed the side what to do. When you will change the side, you will do the same.
Definitely.
See, but this is an issue you have to
Only because of that.
Because of that observation.
Actually,
that was where you was the particular state proceeding and
being that judgment so that next time he will not oppose you. Yes.
21.
May I please, Your Lordship? Here, what has happened is there has been a compromise between the parties for which a joint affidavit we have filed.
Bring them. What is the offense?
Offense is 3787, 85, 385, 294, 506, 34 and 507.
Informant can inform.
I am appealing the informant.
Where is he? He or she, whatever.
Both the parties are present.
Both.
Biraja Prasad.
Mr.
Biraja Prasad? Yes. So Aadhaar card yes.
What was the allegation?
Allegation is that he was scolded by the petitioner and he was scolded that you are earning a lot of money, you should give me money.
Some money.
Some money.
And for that, so many offenses. 1, 2, 3, 4,
and
5.
is another person. Allegation against him, he called one of his friend and told him that not to lodge an FIR.
Anyway. Sanjay Kumar Behra.
My lord. Okay. He's here, my lord.
And Biraja Prasad Chowdhury. At the instance of opposite party number 2, FIR number 2 was raised. The petitioner and opposite party number 2 are present in the court. They are represented by the respective counsel. That's fine. Okay? Right down. The parties have now filed a joint affidavit dated
today, ma'am.
3/2022 inter alia stating stating that the opposite party number 2 has filed the present case due to misunderstanding, and now they have settled their dispute out of court, resolved their dispute out of court, and the opposite party number 2 is not interested to prosecute the petitioner. Not interested to prosecute the petitioner. Okay. Mr. Maharaja appears for the affidavit taken. Affidavits are taken under. Mr. Maharaja appears for the date and submits that the dispute is essentially interested party. And the parties have settled their dispute amicably outside the court, and they have filed the joint epidemic, taking joint epidemic. There is, therefore, there is no legally impediment in quashing the FIR, taking into consideration the submission and all quash.
Yes. All right. There's another accused there. I have filed and
I think some cost should be settled.
Yes, yes, that we are forgetting.
Some cost.
Yes,
You are indulging in all these things. Wait, how much cost?
Welfare fund is a High Court bar.
no, minimum cost because already settled, not all offences are magisterial offences.
That is the reason minimum. 1,000. 1,000.
1,000. Sorry, the High Court
My
bar
lord.
welfare fund.
Again.
Welfare. 1,000. Subject to 1,000 cost to be deposited in the welfare.
My lord, I'll pay. Oblige.
Yes.
22. May I please?
The petitioner has challenged this case. A field and petition was rejected by the learned special judge. And the petitioner is facing trial under section 20B2C of NDPS Act. P4 is the IO. And the P4 has not been cross-examined to certain extent. And the
Why have you not done?
The recall was allowed on the date of examination of the P4. The counsel were appearing for the accused fell ill and left the court premises. That was the reason and the recall.
Where is the testimony?
I may pardon?
Where is the deposition?
Deposition.
Show me the cross-examination part.
Page. No, I have not annexed.
That is the only document you are supposed to annex. And file it. File it. This is the only thing you want a witness to be recalled. The deposition is not there on the record. Where from I'll get whether it is cross-examined, not a cross-examination, whether you
I got it later, that's why I
file it, bring that on record. It is a court of record.
I'll file it, my lord. I pray, my lord. My lord will keep it tomorrow because argument is going on.
Let it be. Argument is going on, defense evidence is over and everything is over.
My lord, I pray one thing, my lord. I will file argument.
You should have been more particular.
In course of the day or after lunch, I will keep it. I will keep.
Don't do all these things. It has to be filed and you don't file complete petition and you want indulgence immediately.
No, my lord, I pray, my lord.
To what extent the court can help you? Tell me.
Let it come after lunch. Before lunch, I will file to the court and also state counsel.
Give him and he has to verify also. And it is IO. Defense evidence might have been over by now. 313 might have been over now.
I pray one thing, my lord.
And everything has to be upset, everything.
My lord, one thing, my lord. By imposing some cost, because 20B2 certain provisions were to be 42, 50 and 54.
Why have you not cross-examined? Who stopped you?
On the date of cross-examination of the witness, the counsel for the accused fell ill and left the court. And that is the reason he could not. In the recall petition, it has been written. And
show me any evidence that he was fell ill.
Voluntarily declining to cross-examine the witnesses. Voluntarily decline.
My lord, bring some evidence, some document where you can say that your lawyer was not very.
My lord,
nothing. One line. The lawyer was not ill, so that.
My lord.
So that entire the system, the sessions court, prosecutor, the IO, everybody has to.
My lord, page 10. That is true. I consider it, my lord. Page 10, para 2 of my petition. I will give some cost, my lord.
Cost is not important. Important is the time of time of the court. And IO, he must be engaged in many things. He has to come back.
My lord,
and the 313 statement has to be once again recorded.
No, my lord. That no.
Now, no, how are you saying no? If fresh evidence comes, then that has to be put to the accused.
If that 84 supplement once is also, if the question is not to put.
Don't throw the judgments on me. I have also done a lot of trials. Don't say if fresh material comes, if witnesses is summoned under 311, a fresh material comes, it has to be put to the accused. Otherwise, everything is vitiated. Why are you show me the judgment which you cited now?
Judgment is on.
Show me the judgment. Come at 2 o'clock. Come with the same judgment which you are citing.
No, my lord has told that
and
the accused.
You cited some judgment, right?
Here 84 supplement 1622 says the question which has not been put to the accused that cannot go against the accused.
Well, my lord has told that the only some, only.
Suppose
Again,
I will allow you a 311.
My lord.
You put some question to that witness. And that witnesses say something against you. Will not that be put to you in 339?
Yes, yes, my lord, yes, my lord. I
Then
am.
the trial has to take again a turn.
Not on.
So calling a witness at this stage is not an easy task.
I will.
And making a statement that your lawyer is ill.
Man,
Nothing is there on record whether he is ill or not.
Page 10
The
para
deposition is not there on record.
My deposition I am in court. No, let it come after 2 p.m. or I am handing over the copy of the deposition to my son.
File in the court. Let us see. Pass over. File in the court. We'll see.
At 2
Let it
p.m.
come.
At 2 p.m. my lord.
I am just passing it over. Let us see. And come with the judgment.
Judgment how it goes. 3.
Let us see. If you can help out. Unless you saw sufficient cause that the witness, the prosecution, or for any reason he could not cross-examine. 311 I can't allow at this stage. See, in the earlier matter I allowed because prosecution evidence is going on.
Prosecution evidence is going on. Here the witness was not at all prosecuted.
Not at all.
I was hearing.
So that is the reason. You have to show me something on record. You have not filed that document. Something on the record. What prevented you from cross-examining?
That is the only ground the counsel appearing for the ill, and that has abhorred in my.
And one line is written, the counsel was ill.
Yes.
Nothing is there on record to show that the counsel was ill. Some medical certificate or something or some description, he was ill for this or that. He had a headache or he was not well for what? Nothing. Nothing is there.
Only
So therefore, on this one line sentence, how can you put everybody to line, If so casually these 311s are allowed, then,
on that
it will
day,
never
the
end.
condition of the defense was not good due to his illness, for which the prosecutor could not be done.
Illness means what happened?
That has not been written fairly. I am concerned. Only
And
illness.
every day some interim orders are passed, then lawyers feel ill sitting outside. That everybody did it. So, but you would expressly say that he is not well because of this. Or some medical record.
But that is not true.
Casually application come at 2 o'clock.
Yes, ma'am.
Yes. 23.
May please also, my lord. It's a Belgium matter, my lord. My lord, NBW order dated.
You were on bail?
Yes, my lord. Earlier bail as per the instruction.
Dated?
I have no knowledge that dated.
He was on bail. NBW issued 2016.
Yes, my lord.
NBW should only purchase the soda. But previous bill, regarding previous bill, there is no instruction.
He was on bail, that's what
Bail.
it says. 1,000.
Yes, my lord. Obliged.
30th, on or before 30th, they appear and seek your remedy available under law. Okay. You will appear in the court.
1,000, my lord.
1,000, yes.
24 Belgium matter, my lord. Bail was granted on 22/11/2021 and NBW issued on 1/8/2023.
23, 500. Okay. 25.
Belgium matter, my lord. 6/9/2006 bail granted. 21/7/2015 NBW issued.
15.
My lord.
2000.
1,000. But why have you come? You should have sent your junior.
Ma'am.
So I will increase the cost now.
My lord. No, my lord, he is my lord. My lord, your lordship kindly see the offense.
1,000.
My lord.
Standard.
My lord.
1,000. Yes.
26. 26, my lord, NBW 7/12/2022. I was on bail, my lord, 25/8/2015.
2000. 2000.
2015.
my lord.
15.
NBW 22.
15/22.
500. Yes. 27.
My lord, 27 13010 Act 205 application allowed on 10/4/2022. NBW issued on 20/11/23.
So, check amount?
Check amount, my lord.
49 lakh.
49 lakhs. That is no, my lord. The check amount is less, my lord. The check amount is 5 lakhs and one is 4,38,000.
Oh, 9 lakh. 1,000. 1000.
28.
Gentlemen, NBW was issued on 21/11/2023 and bail was granted in the year 2021.
21.
My
You don't have dates?
my lord.
Date of the
Date, my lord, 22/11/2021.
22/11/21.
My lord.
Okay, 500. Yes.
29.
It's in the invalid issues on 12th January 23 and you were released on bail on 25th May 19.
19.
19.
500. Yes.
30.
My lord, bail was granted 16/8/2007. NBW issued on 27/2023.
500.
Okay.
Yes.
31.
NBW 21 for 2023. Bail was my lord 26/10/2022.
22.
22 bail ଆଉ NBW 23. 21/4/2023.
500. How many of you are there?
Sir, one my lord.
500. Yes.
44.
30?
44.
What? Oh, 32? No?
Adjourn.
Oh, 40. Yes, 44. Pass over.
45.
45 may mutually.
Nickel.
I'm appearing for the informant lordship.
490 days.
Wife.
Where are they?
The first time it has come. First time the case.
When are you calling them? Tell me. Tomorrow?
Tomorrow. Next week.
Monday? Tuesday? Monday or Tuesday?
Tuesday.
Tuesday.
Item 45.
Ah,
45.
Matrimonial?
Yes.
Tuesday. Bring them.
Pardon me, my lord. My lord, item number 41, I am informant, my lord.
41, the same one?
45. This is 45. Item 45.
41.
Yeah, another item.
41, my lord.
41 is passed.
Bail file पड़े पास हो रही है. This is 45.
14/3.
Next week.
Next week.
देखो ये 41 था.
Launch पर हम.
ना launch पर. Next week.
Let's item 45 on Tuesday.
Tuesday.
Personal appearance of both parties. Please, your lordship.
File will be counted.
Box.
46.
Yes.
46. 47.
47, your lordship, not pressed. Item 47.
Not pressed. Give the memo.
Yes.
48.
48.
Password.
49.
Reach here. What is 50.
50.
What are the defects here in the item 50? 50 defect number 6.
Yeah, that is.
SR is not removed. Special adjournment, huh? 5 days. And he is there in which matter?
28 my lord.
Okay, wait.
Password.
Yes, password.
50 password. 51. 51.
Here also there are many defects.
They have not solved the copy. Not solved the copy.
The 51 the registry has pointed out that there are defects in the petition. The same has not been cured as yet. Advance copy of the petition has not been supplied to the states. Let the petitioner cure the defects and supply the advance copy. Leave the matter April last.
52.
Hmm? 52, 53. Yes.
54.
pass.
55.
Wait, please, your lordship.
Yes.
My lords, on the last occasion, your lordship directed to consider the interim application, which is pending for stay. My lords,
Last occasion, what happened, I don't remember.
no, actually, the notice was, no report was come on that date, but today the tracking report shows that the confirmation of the delivery of the notice to the opposite party number 2. It is,
Then let us wait, I pass it over, somebody may come.
my lords, I have
Somebody
not.
may come, then.
I have no.
What is the case is about?
My lord, case is about the FIR was lodged by OP number 2 on 28/6/2021.
498.
Yes, your lordship,
You are for?
but I am for the in-laws and husband. Matlab, here in-laws, only for in-laws. Husband is not made the party.
Wait, if they may come.
Yes,
then
ma'am.
we will consider and.
Yes, my lords.
Okay.
313 and 354A was imposed at the time of filing of the FIR, but at the filing of charge sheet.
Okay, I understood that matter.
Yes, your lordship.
Wait, if nobody comes, then we'll ask for.
Should I wait after
No,
till
pass
after?
it over, let us see, 2 o'clock. 3 o'clock.
Your lordship.
Item 54, my lord.
The passover is
Oblige, your lordship.
56.
Pass.
57.
When I appearing on behalf of OP number 2.
Yes.
The matter has been settled, I am filing the affidavit. And
But the petitioner is not there.
Your lordship, I'll take time to file my counter. Let this matter come on 20th March. I'll inform the other side.
You will inform.
Yes, lordship, I'll just file my counter affidavit.
Inform he is, you are filing, huh? Supply. You are filing or you would be filing?
I'll be filing within a week. Let this matter come on 20th March, your lordship, after 2 weeks.
Item 60. Mr. Sarthak Naik appears for the opposite party, CBI, seeks 1 week time to file the counter affidavit. Let him do so and supply the copy to the petitioner. Leave the matter.
20th March, your lordship.
Now we will decide the date. Leave something to the court also.
Lordship, it should not be between 14th to 17th. Your lordship, my brother is getting engaged any date after
14 to 17.
that. Any date after 17th.
After 17 you give it. After 17, no problem.
61.
May I please, lordship?
Here.
I have challenged before this honorable court in this issue. The order passed on 7/8/2022 under section 147 CRPC. My lord, I annex the petition annexure 1 filed by the opposite party as a first party. Annexure 1, page 9, page 9. Thereafter, the learned court below had taken the cognizance on the said application, running page 14. My lord, my humble assumption before the honorable court is that the matter is a family property matter. Both petitioner and opposite party are two shareholder and they have got their equal share over the shoot line. In short, thereafter they are staying over their respective share. In the meantime, the husband of the opposite party raised dispute or order section 144 CRPC before the said ADCP cutter, and alternate their dispute. They felt the dispute. Thereafter, they moved to the learned district judge cutter in division. The division they failed. Thereafter, they filed suit, civil suit, and injunction application under order 39 rule 112. There was a status quo order was issued by the learned civil judge. While the matter stood thus, the wife of who is not a shareholder of the property, why now she raised the present dispute,
And the dispute is running since long till late. Only adjourning. I am a widow. I am running to the ADC board. Again and again, there is no fruitful results. I pray before this honorable court either to quash the order or to pass an order expedited within short time final. I am a widow having small children.
Okay. Right. I'll expedite it, okay?
My lord, within time.
The petitioner has challenged the order dated 17/8/2022 passed by the executive magistrate UPD Cutter
My lord.
under section 147 CRP. The grievance of the petitioner is that there are civil disputes which are pending inter se party. The proceeding was initiated, the instant proceeding was, the 147 CRPC proceeding was initiated by the opposite party against the petitioner and petitioner. Petitioner on 17/8/2022. Huh? Some pages are. There are a few pages are missing. That's the defect. Which pages?
Number
Oh,
page.
annexure 1, thereafter annexure 4, 5. Where is 2, 3?
My lord, here.
Huh?
Se to achi.
Apno file rati hu, iti to file nahi. Annexure 1, annexure 4 and 5. Where is 2 and 3?
Two da pachar bandi.
Page number
Pachar bandi.
It's not there.
I will regulate you got court with the court. More file kar dijiye. Only expedite disposal.
That's right, but unless you complete the file record, how can I do it?
I'll clear it here within 5 minutes.
Give this to annexure. Give this to annexure immediately. Right now. Huh?
Page 45 to 49.
Nothing, page 45, 49. Nothing is there. How are you doing all this thing? I don't know.
Well, my lord.
I wanted to allow it, but you have filed this kind of petition.
I will regulate here, my lord. Just 5 minutes.
So thank you that you have not told me that to do it.
No.
This is unacceptable, I tell you. A High Court level, what is this going on?
Pardon, my lord.
Adjourn it.
Yes.
There should be some deterrent. Otherwise, you people take the court proceedings so casual. High Court proceedings. Adjourn it to 21st or 26th. Adjourn.
62.
And you don't inform also. I am giving a dictation, you are keeping quiet.
My lord, may kindly turn to annexure 1.
Which is this?
62.
Yes.
Your lordship may kindly have a glance to annexure 1, page 7. An FIR was lodged by me under 294, 323, 354, 417, 493.
Who are you? You are the.
I was the informant.
Yes.
I lodged this FIR.
Yes.
In the FIR, he was granted bail. He is a police SI who has done this. Page 29. He was granted bail with a condition that he will not commit any offense while on bail. Page 29, your lordship may kindly mark. And he will not threaten 29.
Yes.
The conditions. First is that he will not commit any offense while on bail. Second, he shall not terrorize, not threaten, not terrorize.
Yes, these are the conditions.
These are the conditions.
Then what?
In spite of this condition, I see that opposite party, the private opposite party threatened, and another FIR was lodged under 294 and 506. That is annexure 4, page 30.
Yes. Who is the informant in that case?
I am the informant. Both the cases I am informant, both the cases he is the accused.
Thereafter what happened?
My lord, now I am seeking cancellation of bail on this ground.
Who has granted the bail?
My lord, it was granted by the additional session judge Khalikot.
You have to cancellation, you have to go there only.
No, my lord, I have to move before your lordship for cancellation. Superior court will cancel. He cannot.
No.
He
Bail
becomes,
condition violation.
my lord, he
Go
has,
to that court.
he becomes,
Yeah, the report is also, my lord, noting is there. A report received from the additional district and session judge Kalikot with the report of JMFC Kalikot, my lord, with file B, my lord.
Deposed in ST case number so in spite of this someone issued.
your lordship had called for the status report on the last occasion.
Number of occasions. What is this? Finally, on such day, someone has been issued to her through the registered post ID and as well as through IAC also. Now, what is this?
My lord,
The last order.
now, instead of doing so, I have filed moved before cancellation. They have issued someone to me to go and depose in the case. My lord, deposition is a different part. I will go and depose. I will support the prosecution case or I will not support the prosecution case. That's the one thing. Question is, my lord, here it is, I am before your lordship regarding cancellation of bail.
But you see, last order, at your instance, this is passed. Para 3, read it.
Yes.
Last order. Release this matter on 6/3/2024.
Yes.
To enable J.K. Paddy, learned counsel appearing on behalf of AP Bose, learned counsel for the petitioner, to obtain instruction as regards the reason why the petitioner is not appearing in the court.
Yes, now
He
he has got this
to
summons.
depose the case.
Yes.
And also to intimate the petitioner that the case is posted for hearing on 22/2/2024 before the letter court below, and summons have been issued to
Yes.
her presence only.
Absolutely, madam. I have gone there. I have filed an application for transfer of the case because that opposite party number 2 is now posted in the same police station as SI, where I am to go and depose. So I am fearing threat. So I have filed an application, criminal miscase number 5319 of 24 to transfer that case.
Now, why this court will regulate the proceeding before court below?
Yes.
Your only grievance is some conditions were imposed at
Yes.
the time of grant of bail.
Yes.
And he has violated the condition.
Yes.
So therefore his bail should be cancelled.
Yes,
That's what your case.
that much.
You have to go to the same court. I'm recording it. Write down.
Yes.
By the order dated, write down. By the order dated, what is this bail order? Bail order dated?
Yes, bail order dated is
23/7/2022.
Yes.
2022. The
no, madam, 2020. 20.
2020.
Yes.
27, na?
27, 23/7.
23/7/2020.
20.
The opposite party number 2. Opposite number party number 2 was enlarged on bail by the additional sessions judge Khalikot. While the petitioner was the opposite party number 2 was enlarged on bail, the following conditions were imposed. Page 29, last paragraph. The petitioner submits that despite the aforementioned condition, the opposite party number 2 has indulged in committing crime for which an FIR being FIR number.
My lord, 129 Airfield PS.
120. What is that?
Annexure 4,
129. PS case, PS Airfield case number 129 of 2020.
Yes.
Has been registered against the petitioner.
Against the opposite party.
Sorry, opposite party. On the ground that the petitioner has opposite party number 2 has violated the bail condition, the petitioner seeks indulgence of this court to cancel the bail. So I am of the considered view that for the violation of the bail condition, if the petitioner seeks indulgence, if the petitioner seeks cancellation of the bail, he needs to move to the same court which has enlarged the opposite party number 2 on bail. Therefore, the present petition is disposed of with the appropriate observation. If the petitioner advised so, he may move to the court below for the same relief. Yes.
63 also cancellation of bail.
Same story.
No, but here your lordship must see it's a different. Here, there is no violation of the condition. My lord, I am the chairman of.
I am for the opposite order 2 to 4, my lord.
Opposite part number?
2 to 4. Here before my lord.
You are the accused.
Accused, and we have been granted bail. Madam, may take it on Monday. That's, I'm sorry. Not feeling well.
Okay, it's all right. Monday to happy evening, but we will give it.
Your lordship may fix a short date because I am here.
Short date.
14.
What are the offenses?
My lord, 420. Embezzlement of 2.5 crores of rupees. The learned trial court gives bail without any condition. Without any condition. He has to deposit some money, and that's a proof. It's a bank transaction. It is not that private
But
money.
in the bail is a discretionary jurisdiction of the
Absolutely,
court. If
absolutely,
granted
madam.
bail, why should the Supreme
No,
Court intervene?
absolutely. But my lord, when your lordship is granting bail in 420 where there is embezzlement of money, at least some condition should be deposit. He should deposit.
There is case and also they have also filed a case.
Let me 1,000 cases against me. But it is all in
Let
bank
it-
transaction.
Let it come on 14th, I point out.
Okay. Okay.
14th March.
Okay. Think of settling because cross.
No, it cannot be settled. My lord, cannot be settled. 2.5 crores, let them return that.
Our allegation is that he has misappropriated 11 crores. 11
I am the
crores.
chairman of
Yes.
the trust.
Whatever.
You are the employee who has
Yes.
thrown out from service.
Anyway, we'll see.
He has been thrown out from service.
But it is only cancellation of bail.
Yes.
Yes, sir.
Here.
I may be pardoned, my lords. Item 60, I was on my way. I could not reach when the matter was
Pass
called.
over, ma'am.
My lords, the opposite party CBI has taken time to file the counter, my lords. I just pray the presence of the petitioner being noted.
Yes.
And interim orders to continue, my lords.
Interim order to continue. Page.
Item number, please.
6.
Where Mr. Naik appeared in short time. Mr. Naik appeared in.
My lords. Deeply grateful.
No. But you give a copy.
Yes, sir.
Yes, you give a copy. Yes.
Obliged.
64.
I have also passed item number 59.
Passed over will be taken up later on because she only said that presence has to be recorded. I have recorded. I'll take up the pass over matter.
64.
May I please, your lordship? My lord, in this application, the petitioner before my lord is seeking modification or waiving out of the condition as imposed by the learned court below. I have annexed that order at annexure
that?
1. Annexure 1 starts from page 7, order dated 13/7/2023, my lord.
Bail.
Bail order. Bail was granted to,
Modification, go to that court. Why have you come?
my lord, in fact, what has happened, here your lordship will go, if your lordship will go through the order, the learned court below while granting bail to me has imposed a condition that I need to deposit rupees 18 lakhs in favor of the informant. My lord, how come, if in future I will not be pleaded guilty?
Correct.
18 lakh return.
But you have to
Return
go
to
to
18
the
lakh.
same court for you are filing an appeal against that.
My lord, I have filed this application.
No, you go to the same court. I am giving you liberty. You go to the same court, ask for modification of that part of the condition. Furnishing which part of the condition?
My lord,
18 lakh.
18 lakhs in favor of the informant, your lordship.
Petitioner is assailing the order dated 13/7/2023, whereby his application under 439 CRPC has been allowed and he has been enlarged on bail.
No, my lord. Since I have not deposited rupees
I
18
know
lakhs.
that he has been enlarged on bail. However, a condition has been imposed that a condition of depositing 18 lakh rupees with the waiting. Where is that condition?
My lord, page 9, last two
However,
lines.
the court has imposed a condition to deposit 18 lakhs
To the informant.
However, you have agreed what to do. The counsel or the petitioner submits that the memo of undertaking to the effect that the petitioner has agreed to return the amount.
My lord, in fact, that condition, when the condition was put up, the counsel for the petitioner agreed in the sense that 18 lakhs was supposed to be in fact deposited in the court's.
So you are effectively asking for a modification.
That's
Go to that
why, my
court.
lord.
What is this? right, क्या लिखे? नहीं, impose, internal code, however, the land court below has directed the petitioner to return 18 lakhs to the informant. It is appearing from the the perusal of the impugn order indicates that the said condition was imposed by the court below on the statement of the counsel of the petitioner to return the amount to the informant. Next follow. Land counsel of the petitioner submits that if this was the court below has misunderstood the representation made by the petitioner. They were intended to the petitioner was never intended to return the amount to the informant. And to that extent, he seeks modification. Since since the petitioner is essentially asking for modification of the condition imposed by the court below while granting bail, it is appropriate for him to approach the same court for variation of the condition, variation of bail condition. Accordingly, the petition is disposed of with a direction to the disposed of with a liberty to the petitioner to approach the third additional sessions Cuttack for seeking modification of the order dated 13/7/2023. With liberty the petitioner is disposed.
Lord, in fact, I am ready and willing to pay, but that should be deposited in court's account and that too in installment basis.
What circumstances you have said, what the record says that it is the statement of
It has been
lawyer.
aborted, my lord.
Go and tell that this statement was not made. How do I know whether you have made the statement or not? Why nobody knows it? Yes. It's senior counsel. No, not that senior counsel. Which is that is there. Yes, sir.
I don't know. 72.
72. Yes, 72 number.
72.
Is there? Opposite party?
Yes, not state, my lord.
It is state.
Now, this is that case, my lord, where the police from the Bangalore had come here to, my lord.
The other day you were arguing some matter and it reminded me.
Yes,
Something. Some other matter you were arguing.
Yes.
He was arguing in some other matter. The similar situation.
Sure.
He reminded me that Mr. Das argued that the same.
Yes, same. My lord,
Yes.
my lord, I had on the last occasion, my lord, given to the hospital the charge sheet, my lord, that was submitted at Bangalore, the Jigani police station case, my lord. And also I have received the, my lord, the charge sheet submitted by the, my lord, Kandhamal police.
You are supposed to file something.
No.
Last order says Mr. Maharaja and Extending Council for the state seeks time to file the copy of the charge sheet in
Yes,
Sundargarh PSP.
Yes, I have already filed charge sheet.
Huh?
Yes, absolutely.
You file.
File the charge sheet.
Yes.
My learned senior has also received the charge sheet copy. Yes, I will. Yes, I will. I will.
Are you ready?
Yes, I'm ready. Yes.
Then I'll fix it 3 o'clock so that it will take time.
It will take time. Yes, it will take time. If it is 3:30, I think I have a matter item 32 before the Honorable Chief's Court.
Then what do you want? Shall I fix some other day?
3:30 minute. I think by that time I'll be over there.
Okay, 3:30.
Yes.
At the end of it.
Yes.
Yes. No, something. Yes, sir. Yes. Both the senior counsel are there. Yes.
Sir, 65.
Sorry, I didn't see you, sir. Both of you.
Sir,
Yes, 60.
65.
in fact, my learned senior Mr. Naik was peeping through the door. He had not come to the door.
Scared of Mr. Das.
No, I am not against it. Appearing against him. It's another case. It's a case man where I am appearing for the opposite party regarding release of the vehicle in my favor. That was challenged by the petitioners and
Who is there for petitioner?
stay was granted.
I am for the
Stay was granted. Repeated adjournment was
Yes.
I mean, with pardon, my lord, I'm in VC. I'm for opposite part number 3 in this case.
Item 65?
Yes.
65.
Okay. How, yes, so many hearing has taken place. What is this matter? It is only release of vehicle.
Release of the vehicle, my lord, involving a short question of law, whether a person who is entitled for release, whether he is entitled for the bus, my lord, whether in favor of him, the bus will be, vehicle will be released, or who is the registered owner. The difference between whether the vehicle shall be released in favor of the registered owner merely because somebody is a registered owner or somebody is entitled for release, my lord. That is the question of to be decided. It has already been decided.
Who are you?
My lord, I have taken the vehicle from the registered owner because he has borrowed, my lord, the amount from a particular bank, unable to pay, unable to ply the vehicle, made an agreement with me, my lord, made an agreement with me that I will pay the bank amount, I will pay a lump sum amount to him, I will pay the installment regularly, and I will ply the vehicle. So under that agreement, my lord, I am plying the vehicle. On one occasion,
The original registered owner, has any objection?
Yes.
Yes, my lord, I am the registered owner.
Yes, an objection.
They have made an agreement, my lord, agreement I have filed.
That agreement has
And
not been
the
registered.
SDGM
I
have-
can't enforce that agreement in this.
My lord, your lordship may kindly see the revisional order, my lord. It is elaborative, my lord, that
Yes.
the learned court below has, my lord, extensively dealt with the matter. Yes, sir. That is no error. My lord, taking into all some, my lord, materials
Yes,
on record. Your lordship,
Mr. Sastri, you are appearing for whom?
Indecent, my lord, opposite part number 3. Indecent.
I don't think you have any problem here. It is between the registered owner and the owner who has entered into agreement to purchase that and paid the money to you. You have
Yes.
got your money. From Mr. Naik's client, you might have got the money.
Yes, yes.
Yes, let us see the reasoning. If the reasoning is good, then I don't need to interfere. Let us see.
yes, lords.
What did the SDGM did? SDGM allowed.
SDM released the vehicle in their favor, my lord. I carried a revision to in the court of the, my lord, Sessions Court. Sessions Court reversed, relying on a decision of this honorable court, my lord, directed to release the vehicle in my favor on the ground that I am entitled for release, not merely because he is a registered owner, he will be entitled, my lord, and for which he has relied on a decision, my lord, that is in the revisional order. You know,
Page 26, from para 6, my lord, my lord, can see the
Reasoning.
observed reasonings.
Yes. Para 6.
Yes, yes.
I have given anxious consideration.
Yes, my lord.
Rival submission of the party.
Grounds and materials available in
order.
Is found that crowd.
By the IO in connection with another case. No disputes.
Courts may kindly directly come to para 7.1. Those are facts which are not disputed by either party.
But you have paid full amount.
Yes, man. Para 7.1, you will also may kindly come. Para 7.1, my lord. The reasonings given, my lord, in the next page, you will also may kindly.
No dispute with regard to the fact.
Yes, ma'am. Yes, ma'am.
There is no legality to the of the article in the bill and the rules containing these concerns provided under the property.
Important is, my lord, the learned SDGM Balashore, while disposing of the applications under section 457, last
Yes.
CRPC has not reflected the single word in its order as to who is entitled for possessions of the seized vehicle. He has disposed of the applications.
If the factual positions are admitted, you have taken the money, You
I
can't
ha-
be a dishonest now today. to
Yes,
say
my
that
lord,
release the vehicle on
I have taken the money
Huh?
and thereafter I have refunded.
What
the
interest
same.
you have now?
My lord,
What interest you have?
the
You have
finance,
taken the money also, vehicle also.
only two, they have structured only 2 lakhs I have receipt. But my lord,
You file a
the
report.
the finance amount is 20 lakhs, my lord. The finance
But you
amount is
have
20
agreed for
lakhs.
14 lakhs, you have taken.
Yes,
it.
yes.
My lord, that document is not a registered one, my lord.
All the things in the.
And about the money receipt is there. Money receipt.
457 proceeding, I will consider. This is a 480.
And at the time of a seizure of the vehicle, my lord, the vehicle was with my possession.
No, it appears to be your client is dishonest. You taken the money and now you are.
Taking the vehicle also.
And thereafter I have refunded the same. My lord, this is my responsibility, my lord, I have refunded the same.
No. You have agreed.
And if
You have see, fact of the matter is undisputed fact. 14 lakhs 50,000 rupees. You have agreed to sell the vehicle.
Yes,
Agreement was entered into. They have paid the entire money. Now,
Yeah, but-
unfortunately, there is a case.
My lord, he has paid only 2 lakhs, my lord. As per the statement of the bank statement, my lord.
My lord must go with the documents available here.
My lord,
I don't think any unreasonableness in this order, so that I'll not.
because my lord, at the time of a seizure of the vehicle was with my possession.
That can, you can.
That is,
go to
here is the report, my lord.
Civil court.
You have many remedies.
Annexure 2, my lord, your lordship, can you have a glance to the annexure 2?
Okay.
While my vehicle was run from Chennai to Calcutta with the transport of the goods, my lord, due to defect of that machinery defect, my lord, I have.
Okay, I'll interfere. You pay back the 14 lakhs, bring 14 lakhs 50,000 rupees check here, draft here. I will set aside.
I will take instruction, my lord.
No,
Whether he has.
Money with the money.
By this,
Whether he has received all
You have
the.
taken the money. If you want me to exercise.
My respective submission, I have received only 2 lakhs, my lord. This is my respective
and
submission.
bank lawyer is appearing, my lord. He must admit that I am paying. I have paid. My lord.
How much money he has?
Just a minute.
Yes, Mr. Sastri.
Sorry, I was disconnected. But when the lien lies on the borrower has paid back the entire money. We are least concerned where from he got. Actually, he is not supposed to make any kind of agreement during the pendency of loan account. After the payment was done, we have made everything clear. Only NOCs to be released in favor of the borrower. But incidentally, as the dispute is there, so as your lordship directs, we are ready to release the issue the NOC in favor of the person as your lordship directs. The payment has been made. And the borrower has paid to our money.
But by us, yes.
Made the full payment.
And your lordship may kindly see
My lord,
the last page, my lord.
The opposite part number 2 only deposited at 2 lakhs. As for after the order of
The
the
bank is satisfied. How does it make difference?
bank has satisfied about the 20 lakhs, my lord, the finance amount, my lord.
But bank
But
says
the
that
2
money
lakhs he has paid. Only 2
Well,
lakhs.
That is to be decided in a 482 application, my lord.
Again, 2 lakh to say there
It's not a question of facts.
Your client is very smart.
No,
Right?
my
You
lord.
must admit that. Very smart. You take,
Well, law is well
money,
settled.
want to take the vehicle out.
Your lordship may kindly say, then the next page, my lord. What the,
Anyway, I will not interfere. Not interfere. But the only thing is, if you get that 14 lakhs 50,000 rupees.
by that process, you will take time, my lord. I will obtain instruction that will delay the matter, my
draft,
lord.
you come tomorrow. Come with the draft.
I will take instruction, my lord, whether my client has received the entire amount or
If you
not.
want that I should interfere in this matter, give back his money. Take the vehicle. Face it, whatever.
ଯଦି 14 ଲକ୍ଷ
You can't have
50,000 ସେ ରିସିଭ୍ କରିନଥିବ କଣ ଦେଇପାରିବ? I admitted, my lord,
That
that is only 2 lakhs I have received and thereafter I have refunded it.
that is what is the finding is. What to do?
Yes.
That is the factual position is not disputed. That's what the court says.
Your lordship can glance to the order of the Lord SDJ, my lord.
That has been already set aside. Your lordship may kindly see the last but one page of the Sessions Court order where the Lord and Session Judge has relied on a decision of this Hon'Ble Court. The para 7.1, my lord. Last
that
time.
he might have paid to you, but he has paid it to the bank.
Yes.
Bank says that the entire money is paid.
By number 2. No, my lord.
Agreement.
Yes,
there is
they should have to show, my lord, they have deposited all the amounts. Only my respectful submission, my lord, 2 lakhs they have deposited after the order of the loan and
How much loan you have taken?
20 lakhs, my lord.
20 lakhs. If the bank says that the entire amount is received, what is your problem?
I have no.
Bank says that the entire amount is received.
Bank received, my lord. I have no.
Bank received from us, not from him.
No, third party gave it over.
Bank received from us because who
Either he might have paid or you might have paid.
You should have
You have not paid.
My lord, the opposite party number 12 may kindly direct to file the receipt.
But this is not the court, my lord, where receipt will be filed.
What is this in 457? You want.
I admitted, my lord, I am the registered owner, my lord. And out of 20 lakhs, he has only deposited 2 lakhs.
We have given the receipt, my lord. My friends said.
During the course of the ballot hearing in the ballot to Sessions Court ballot, revision hearing ballot, the IO has called for to submit a report. IO has submitted, your lordship may kindly come to.
Yes.
Ballot, kindly come to page 27. It is further appears from the report of the IO that petitioner has paid 11 lakhs 57 petitioner.
Where is that, sir?
My lord, the page 27.
Here, at the top.
Bottom, my lord, it is.
It is further appears from the report of IO that.
The report of the IO that petitioner has paid 11 lakh 57,252 as repayment of loan out 2711.
And 180 is paid to you.
We have also given the receipt, my lord. It's available in your lordship file.
No, my lord. The receipts.
The agent of copy nature don't know.
That all the receipts are not deposited by opposite party number 2, my lord.
I have given the code.
No, that is the another person. No, my lord.
You have admitted 1,80,000 rupees advance was paid.
Yes.
And 11,57,250 was paid to the bank.
Yes.
IO report.
Yes.
So the entire amount is made good.
Yes.
14,50,000 rupees, roughly. So therefore, the revision code is correct in releasing. And towards the payment of the loan in the 27 installment he has paid.
Yes. No, my lord.
That is what is the finding is no will not make no, sir. The IO has given the report. Judgment reserve. Judgment reserve.
My lord, item 66. My learned friend is there, interim order is there. I have to file an affidavit in this case. Item 6 is next item, 66.
Lordship, and for the petitioner.
The lordship may continue that. Your lordship may continue that interim order.
Why lapse?
It has lapsed because in a particular date, probably the court missed out that interim order.
Any case, the interim order may continue. Let it be there.
Same arrangement.
My lord.
Interim order to continue.
Give the date of the last.
As a date said.
It was passed on.
You tell me.
28/11/2023.
The interim order passed on 28/11/2023. Remaining. See, shall continue. Shall continue. Mr. Marana will file reply.
I'll reply. The date.
Pardon to mention, my lord. Pardon to mention, my lord. Item 49 got passed over in the display board. It was showing some other, like item 49.
After launch.
Grateful.
Yes, sir.
68, 69, two better. So the lordship had issued notice granted interim orders. The NGT order, which has been passed in one case.
Oh, yes, I remember.
Now that
was the basis of the complaint, something of that sort.
Yes, your lordship. So now orders are division bench has stayed it and 482 bench quashed that order in connection with another case. The AD has not returned in both the matters. I had taken out notice.
Notice was issued. For 68, 69, notice was issued to the opposite parties. Number 2, the service is not affected. You will file fresh this thing. Awaiting the service, adjourn the matter so and so. Meanwhile, Mr. Sodangi submits that he would be placing on record for the documents. The document would have filed for them. So that we will, for the document, lease the matter on sale.
Last week, first week of April.
Last week, what happened?
We had talked the other day.
Okay. First week, maybe.
4 तारीख, 5 तारीख.
He will be busy in the- I know he gave the idea,
Yeah,
giving wrong idea to everybody.
my lord, I am helping.
Because
Your lordship, that interim order was.
by that
Interim order.
process, our election will be hampered. Our bar election is on 30th. That will be hampered.
The wrong date you have fixed.
Yes.
Wrong date you have
I
fixed.
need to pardon.
Many would be not there.
I
Anyway,
may be pardoned.
Yes.
Item 50 becomes impropriation.
item 50 influences removing display of 55 days. Then consider petition says that if it would become infectious, he files the memo for withdraw. Dismiss as infect. Yes.
After lunch, my lord, 73 will be taken off.
Yes, yes.
ସେଟା ଦେଖିବେ ପଢିବେ ତାକୁ କରିବେ ଆଉ।
Two 506-307. Is in custody since 2021.
Yes, Mr. Praras. See, his father died today at 11 o'clock. He's the only son?
No.
Cremation must have been. I will take instruction.
Last visit.
Huh?
Body is there. Lordship may take up. Let him get the.
Which police station? Just tell him so that he can get him.
King's Hospital. Died in the King's Hospital. Yesterday he was admitted.
Yesterday, the matter was listed.
No.
Also, yesterday, the father was admitted.
His father was admitted.
Lordship may take it at 3 plus. I will take.
Today.
Almost. The corporate of nature. How the corporate of
Today.
they did Kuptan, I would have did it. By then, they did.
Yes.
But who police station was it?
22.
22 could may have been.
The detail PS case would not be there.
Yes. Yeah. Give.
I have already given.
Which paragraph? This paragraph, the judgment. Let us see first the cross examination. Decline.
Decline.
Cross examination decline. The court has done your job. Yes. Show me the judgment, which paragraph?
Judgment, my lord. Till 63.
Yes.
Page 281, para 5, towards bottom. The Supreme Court further gave guidelines which are enumerated as follows. While dealing with an application under section 311 CRPC, carried along with section 150 evidence has 180. The following page will have to be borne in mind by the court's manner. Next page, madam.
The court is right in thinking the new evidence.
Para 3, madam. You are giving certain guidelines.
Evidence of any, yes, which?
Para 3, my lord, if the evidence of invalidity appears to the court to be essential
to the judge decision of care. It is the power of the court to summon and examine.
So when this can be done, if you give the proposed question. Where is your in application proposed questions?
Proposed question.
Then how the court will arrive at the conclusion?
Madam Mayor, dispose of. I will give proposed question with some cost. From Barampur to Patrapur, 30 fresh petition with cost. What cost? The IO is from Barampur to Patrapur, 40 kilometers. From some cost we imposed, the cost we deposited in the court and the cost will be taken by the IO.
Right. The petitioner is an accused in which case?
GI case number 41 of 2021 pending in the court of law and third action
Section.
Section 20B2C, my lord.
Section 20B2C.
The petitioner moved an application under section 311 seeking the recall of the PW4. Who is the IO in the present case? Have you filed this? Already?
Yes, ma'am. Yes, ma'am. I have given it.
The deposition of PW4 indicates that the defense has not cross-examined the said witness at all. The the petitioner in the application under 311 submits that due to ill health of the defense counsel, the cross-examination could not take place. Matter before the trial, the matter is at the last stage, full stop. The counsel for the petitioner relying upon the judgment of the coordinated bench of this court reported in 2016 bracket 63 OCR 279 submits that the court has enumerated the court has laid down the guidelines to deal with the application under 311 CRPC. As per the guideline, his prayer ought to have been allowed by the court below. However, the trial court has rejected the same. He relies upon the para 281 last time. He relies upon the guideline formulated by the coordinate bench of this court, which reads as under. Since in the application under 311, no proposed questions were mentioned. It is essential that the petitioner needs to furnish the proposed question before the witness is put to cross-examination. Taking into consideration the aforementioned, the order dated, which is the order dated 17/2/2024 is Sarasa, and the trial court is directed to afford the petitioner a single opportunity to cross-examine PW4 before the said witness is summoned for deposition. The defense counsel should furnish the proposed questions to be put to the said witness, and the trial court will evaluate the relevancy of those questions and thereafter summon the witness. The petitioner is also liable to pay a cost of rupees 2,000 to be deposited before the court below to facilitate the witness to travel to the court and depose. It is accordingly disposed.
Madam, urgent copy. I am thankful to Mr. Pararaj. He has supplied me the. I am thankful to Mr. Pararaj. While I was searching for nut, he supplied me.
Yes, that is how you should do, you know.
Yes.
If something is in your favor, the prosecutor also should help. What is wrong in that?
That what is so reciprocal action, my lord. It is lacking on part of my
Nice
dear
to
friend, my
you
lord.
had- Yes.
33.
Petitioner is in custody since 31/7/2000.
Yes, but 376(3) is there, my lord, notice to go.
Notice to the informant oblique victim.
Yes.
Yes.
And CDL. Lordship may kindly fix a date so that I will
Yes,
also.
fix, he'll fix. The dates will be fixed. City court.
City court.
City, what is the briefing for the? Yes.
35.
Put a date demo data mo inti.
35.
35.
May I please? Lordship may see the last order, Lordship. Lordship has, as the victim was examined, thereafter Lordship will consider the bail application of the petitioner. This is a case and counter case, Lordship. The victim has lodged an FIR after becoming major. She has taken an allegation of when she was a minor. The petitioner has taken has physical relationship with him, and
I'm not able to follow anything.
Lordship, the FIR allegation.
After lunch, you are supposed to have little energy.
Lordship, I didn't have my lunch.
Yes. Tell me, little louder.
Lordship, the allegations are under section 341, 323, 294, 354C, 354D, 506, and 417 and 34 of IPC, Lordship. Read with section 6
You
of.
have circulated the nude photograph of the victim.
Lordship, they have a there is no there is no
Fake ID.
evidence regarding the circulation of those photos, Lordship.
Fake ID in social media.
Lordship, regarding the viral of those photos, there is no evidence.
What is the stage of investigation?
Lordship may see the last occasion. Lordship has asked my learned senior when the victim was to examine. The victim was already examined on.
Let him say we are.
But taking advantage of those photographs, my lord, the petitioner is, my lord, always, my lord.
Now, what is the stage now?
Exploding. And here now, my lord, charge sheet has been filed.
No, trial stage. Whether this girl is has already been examined.
Well, that's why your lordship has directed, my lord, on the last occasion to get the victim examined
on 29th February
for the
2000.
court below, and thereafter, my lord, the statement of the victim may be produced before the honor. But that has posted to 29/2, my lord. And in the meantime, I don't have the up-to-date instruction. Your lordship may.
That is next week.
Yes.
Next week. Yes.
Lordship, a day maybe. A specific day maybe.
No, yes.
36.
May I please? My lord, the case is under section 420, 408, and 34 of the Indian Penal.
Extremely sorry, my lord, on behalf of informant Mr. Mahapatra. Only I pray for one password.
In this case.
My lord, on behalf of informant, he has appeared.
Yes.
Sorry, I'm very sorry, lord.
Password.
Obliged.
Yes.
40. The password.
May I please? May I please, your lordship?
Yes.
My lord, petitioner is a lady, my lord. She is under custody, my lord, since 8/12/2023, my lord.
Yes.
If your lordship go through the affair as well as the one single statement of some of the witnesses, my lord, I am not author of the crime. Author of crime is the informant, my lord. He has persuaded his friend that collected some amount with the ensuring that some service will provided them. Only allegation against me, my lord, whatever amount he has collected, he has deposited in my account.
Charge sheet is filed.
Yes, madam. On 15/12, charge sheet has been filed. I have also annexed.
Yes.
I have annexed.
2 lakhs rupees. 2,60,000.
60,000, madam.
Statements are there, my lord. That the money hasn't gone, my lord, to the petitioner's account. That is.
Money. Why don't you pay back and finish it up?
My lord, whether amount has gone to my account or not, that will be subject matter of the trial, my lord. Consider the stage of trial, my lord.
Don't say that you have your account, it has gone to your account. Why don't you pay and ask for quashing?
Just before my friend is saying that only money has been come to my account. You are saying.
No, that is the allegation. That is the allegation. That is the very.
Page 6 allegation. Page 6 allegation of the finishing allegation in the first paragraph. Page 6 allegation. Granted. Granted. Don't want to.
Right.
I have granted the bail.
Problem.
42.
May I please, Your Lordship? It is not I for interim bail, madam. It is
My lord,
suspicious
your
in
lordship
marriage.
consider the matter on merit. My lord, the CD has come.
Hmm.
16 statement is there. My lord.
What is the FIR is?
493, man.
493.
Yes.
Yeah, just see what are the statement.
ମୁଁ ଆଜିକୁ 3 ବର୍ଷ ହେଲା ବେଗନିଆର ଅନିଲ ପ୍ରଧାନ ଭଲ ପାଉଥିଲି 40 kg 305 gram before investigation. During the currency of the investor, let him come after the completion of the
No, my lord, what I submit that is in the other co-accused persons whose bail application pending before the Honorable Court, and that date was fixed on 11th March. And that is bail application is 256 and 11. With along with 749 and 256. 749 24 and 256 24.
44. 44.
44, what happens?
44. Mention that.
46.
Requisite has already been filed. It's not for acceptance, Your Lordship. Requisite has already been filed. On 27th, I filed the requisite.
You filed, huh?
Yes, Your Lordship.
Although the requisites have been filed to serve the party, but there was delay. The same may be condoned and process may be issued to the opposite party number 2. Written evidence. Yes.
48.
May I please?
Yes.
Madam, last time notice has been issued, but the report, tracking report is at flag 2, which confirms the delivery of notice.
Delivery notice. Notice delivered.
Tracking report.
So least it next week. Let us.
I leave it to me.
We don't know whether he may come. Service is complete, huh? Yes.
My lord, I may pardon. Date may fix.
Date he'll fix. Yes.
Except 12 any date. 12 have some.
12 is not possible at all. They can go to next week.
14 or 15, as your lordship.
He will do it.
But
yes, next.
49.
Yes, 49.
May it please, Your Lordship.
Yes.
Lordship, on the last occasion, directed us to file the requisites for issuance of notice to the opposite party number 2. But the noting has come that the address is not found.
So what to do? You file the press.
My lord, we have filed it 2 times already. And
the address. Search for the address.
this is the only address that we had that is found in the FIR. So we are not staying in the same location where the informant is staying.
498.
My lord, this is a very peculiar case, my lord. What happened is that marriage took place in 1993. Judicial separation directed in 2004. From 2004 till 2021, there was no contact between the petitioner as well as the informant. Suddenly in 2021, this FIR was registered against us.
Thereafter she disappeared.
Thereafter, we have no contact.
Disappeared.
And Your Lordship had on the last occasion questioned that after such a huge delay.
Serve the notice on the opposite party number 2. Then the repeated attempt by the petitioner to serve the notice on respondent 2 has failed. Let the notice be served on the opposite party number 2 through the IIC. Which IIC?
Maithili, my lord.
Maithili,
Malkangiri, district Malkangiri.
Mathili.
Mathili.
Through PS, IIC, PS Mathili, district Malkangiri. Additional copy may be filed. We'll file an additional copy and we'll send it. We'll see.
Okay. Lordship, my humble submission. In the meantime, the proceeding.
In the meantime, the proceeding before this, where is that application?
My lord.
Application, right? 2379.
My lord.
2379 allowed and they see the prayer. Yeah, application.
My lord.
Please see the prayer. I'll allow the same prayer. See the prayer.
Lordship is asking to see the prayer in the
Prayer
IA.
in your IA. Why are you filing this kind of application? I don't understand.
Well, I am
You have
appearing
reduced
for,
the High Court to less than a kachari.
I'm appearing for the first time in this case, but I have not.
First time, second time, I don't know. You want that some interim order to be passed? In which application I passed? This is the interim application. You file better application and come. Don't pass any interim order. Don't pass in it. If you are so casual, then face it.
I'm extremely sorry, my lord.
File. How can I allow the application? There is nothing. See the application.
It's nothing else.
Nobody can think up.
I understand, ma'am.
No order in it. Just simply share.
54.
I'm extremely sorry, ma'am.
Substitute application. Do. Yes.
Lordship, may kindly grant me liberty to file a better.
No, why should I give liberty? You file it. Come. Why should I give liberty? You may file, you may not file it. If you want interim order, you should file proper application. Yes.
May please, let's see.
I think next time I'll start imposing cost. Now what will happen is at least the junior members of the bar should be serious. While filing, at least they should see it what they are writing.
Yes.
What is happening, they write whatever they want, copy paste anything. And these people copy paste and pass the order. Thereafter, a modification application comes.
Right. So there
In some application, there is nothing.
Nothing, yes.
Extremely sorry, but my lord, this application was filed by Mr. Lambodar Achari.
I'm not saying anything against you. I'm saying that in general, this is what is happening.
We are never going to commit this error.
How to correct the bar?
My lord, we will never commit this error, my lord.
How to correct the bar? The secretary is there, he'll...
Secretary is there.
How to correct the young member of the bar? So casually they are filing applications, petitions and all. Now first we have to see his petition.
Yes.
Then we will decide.
I seek for forgiveness, my lord.
Okay. File application.
May I please, let's say. Well, the petition, the GR case was initiated 54. My lord, the GR case was initiated on the basis of the final order of the State Rule Scrutiny Committee. In FC's case number 22 of 12, declared the petitioner belongs to Hadi by caste and Hadi Christian community, but not Kandha, but not a Kandha Christian. My lord, can you glance the final order? Here is the final order is the FIR. Running page 14, my lord. Para 4. Para 4. There is no caste certificate issued in favor of the present.
What is your case? Is 420 and
420? No 420.
Where is the caste certificate?
No caste certificate has been issued in favor of the present petitioner.
What is the relevancy of caste certificate in 420?
420, my lord, can you glance the page 14, my lord?
What is the allegation against you?
Allegation against the scrutiny committee clearly reveals in his final report, if any caste certificate of justice has been issued to the alleged Alakas Malik and his family members, if so, steps should be taken, cancel the same. If any.
Last occasion you prayed for filing of some documents, but you have not filed any sorts of documents, and you are pressing.
Last time there was some issue came up.
Yes.
You said that I'll file some documents.
some documents. So
My lord.
he has not filed any scrap of paper. And he again repeating the same argument, I have to stay.
पहले obtain a certificate copy. Summon ହେଇଥିଲା summon ତାକୁ ହେଇଛି ବର୍ତ୍ତମାନ
Someone that is not the ground.
no caste certificate
The
no caste
original thing
certificate
is that
no
there are 9 witnesses have already been examined.
examined but my lord no point of time no caste certificate has been issued in favor of the patient petition.
It's a case of 2014.
14 my lord.
That's why you are directed to file some documents.
No. In the year 2023, someone issued someone has fresh someone issued in favor of the against the present petition of matter. The state level scrutiny committee clearly stated that
The
no
trial is at advanced stage. What he says, trial is at a very advanced stage.
trial is going on.
Why have you come at this stage? That's what he is asking.
Yes.
And
It's a
if
case
the
of
trial is at
2014.
advanced stage, let us understand who has deposed against you, who is not. Where is this?
My lord, if there is no caste certificate,
That will be tested
Yeah,
at the time of trial.
There may be some corroborating evidence also. We don't know. Where is the deposition?
no, my lord. No, those state, my lord.
Yeah, how can we scuttle the trial at the advanced stage without knowing what is the deposition?
No, my lord. What I submitted, my lord. The state level scrutiny committee formation in view of the honorable appeals court judgment, Madripalli judgment reported in AR 95, AC 94. The scrutiny committee formation for verification of caste certificate. If there is no caste certificate, why a proceeding initiated against me without any basis?
I don't know.
If there is no caste,
I don't know. Neither the prosecutor knows.
my lord, if there is no caste certificate issued in my favor
But
at any point of time,
still, why the case is going on since 2014?
yes, my lord.
The
Going
trial
on.
court,
It is going on.
There must be some deposition against you. Oral testimony, something might have come.
Not my lord, my
The
lord.
original thing.
My lord.
Original thing से कौन है देखो यही point टा कहते ले ये लॉस में कहीं turn to page 21. That is the original point which has been raised.
FCC 22.
21. On the marginally noted, the word started on the marginally noted.
1 minute, 21.
Minor. 21.
Yes.
On the marginal noted that your lordship has pointed out this fact for which he undertook to file some document to testify his testimony. But instead of filing any documents, and it is clearly stated that from the office of Collector Kandhamal Fulbani, ST Development Section T, that containing Xerox copy of final order of the state level scrutiny committee on its final order on alleged fake certificate case number, Mellon. That is important. 22/12 against the accused Alkas Malik, son of late so and so. As per the direction of the final order of the state level scrutiny committee, the DOO Kandhamal set the final order of the scrutiny committee to PS for registration of a case against the accused persons.
My lord,
that is why.
My lord, can it come to page 8? That is the reference. The scrutiny, the final order treated, this may kindly be treated as FIR. That is the reference. Scrutiny committee final order to FIR treat correctly. That is the reference, my lord.
To answer one thing, 9 witnesses have been examined.
Examined, my lord. Examined.
What are the evidence came in record? Let us see, understand it.
Well, I will produce next date. I will produce next
The
date.
trial is going on that pace. And
Kitchen
you want me, the 2 pages you have filed, I want to completely wash everything and
yes, my lord. I will produce the deposition copy. Very next date.
simply urgent. Yes.
Obliged.
55.
May it please, your
Yes,
lordship.
madam.
I think no one appears in this
Mr.
case.
What is
One more time, maybe given so that anybody may appear because the notice has served.
That the tracking report at flag D confirms the notice.
Confirm the delivery of notice.
Yes, your lordship.
That is there. One more time may be given, somebody may appear.
In the meantime, my lord, the interim stay may be granted.
Coordinated, yes.
If your lordship pleases.
Return. Notice was issued to opposite party number 2. Despite service, nobody has entered appearance. Nobody has entered appearance. Properly do interim application. Where is your interim application?
My lord, 3053 IA.
Properly you have written or not?
Yes, your lordship. Everything is mentioned.
Merit, so far merit is concerned, there is nothing here. If there is any chance of settlement, matter altogether difference. But so far the merit is concerned, she has categorically and specifically stated against these parents or in-laws members.
No, my lords. In every place, Sasur, Sasu, Ja, Dedsuro, empty korthile.
No, specific.
So, Sasu, in each and every para, there is severe contradiction in the entire affair. But the plain reading of an affair.
Can't be gone into it.
Yes, your lordship, but it creates severe doubt on the version of the informant when 313.
Why I am saying is, once stage order is passed, she will come forward.
Yes, sir.
And then we'll settle.
Will be deeply obliged.
That's the reason I'm.
Yes,
that
sir.
is the reason. That is allowed the application. Huh?
Deeply obliged.
Further proceedings in GR case number 769 of 2021, arising out of ASCA PS case number 416 of 2021, pending in the court of JMFC, ASCA Ganjam is stayed.
Deeply obliged.
Once stay order is passed, if they are avoiding, they will come forward.
56.
May I please your lordship, my lord, in this case, my lord, the petitioner challenging the order passed by the district sessions judge, Kendrapada, my lord. In this case, as a refused to release the vehicle, my lord, two-wheeler vehicle, confiscated.
Yes.
Exchange Act.
Lord, so can you turn to page 24? 24.
Yes.
The para 5, the word starts perused. May I read?
Yes, there is
the original case recorded in 2SCC case number so and so. This case number so and so. It reveals that one Hero Honda Glamour motorcycle bearing registration number so and so and chassis number so and so has been seized in connection with the PR number so and so dated by the Inspector of Excise Kendrapada range for the offence on section 52A I of Odisha Excise Act. On verification, it is found that the present petitioner is the accused in 2SCC case number so and so. So also he is the registered owner of the said seized vehicle. The learned SDGM Kendrapada by letter number so and so, dated so and so, has sought for status report from the Inspector of Excise Kendrapada.
Confiscation proceeding has been initiated.
Yes, that is the whole difficulties. Only the confessional
457 can't be allowed.
Yes.
Because confiscation proceeding you contest there.
Yes. And notice also he received and he is to file so cause.
What is it?
The recent judgment, my lord. Recent judgment of the High Court, my lord. In this case regarding para 9 of the. Taking all these factors into consideration as also the statutory bar referred to herein before, this honorable court each of the considered view that the release of the vehicle, if at all during pendency of the confiscation proceeding or the appeal, can only be subject to the final outcome thereof and not absolute. In other words, the order
Okay,
of
you see the application under 457 CRPC moved by the petitioner has been rejected by the court below on the ground that confiscation proceeding has already been initiated in the present case. Mr. Maharaja appears for the state and submits that the confiscation proceeding is the advanced stage. Let him seek instruction at the present status of the confiscation proceeding. Urgent. This judgment says that subject to outcome. Let us see what is the outcome. I can entertain the application, but subject to outcome of confiscation proceeding. Let us see a confiscation proceeding what is happening.
1 year the 2 wheeler.
Let us see.
1 year.
Short date.
Allegation of 7 liter of beer.
Release statutory
bar.
Only the authorized officer is empowered to release.
That judgment is not helping you much. That judgment only says that subject to outcome of the appeal in the confiscation proceeding, this vehicle will be released. There is no bar. But a confiscation proceeding has been started. Let us see. Yes. Next.
Date may be.
Date. Yes. 59. 59. Yes.
Millard, due to my health issue, I am unable to file the requisite on time, and so that the notice could not be
File
issued.
the Press requisites to serve the opposite party. Yes.
Your Honor, I have filed an IA application also, and court had ordered me to show any judgment regarding 482 CRPC and
No, I have issued notice, you file the requisite first. You, without filing requisite, you want interim order. File the requisite. Yes. Next. Yes, today, same day. Let it come, let it come. I'll come one. Finish?
Item 67.
Okay, there are 67.
67. Sir, I will file the requisite by to 8.
Yes.
67 adjournment.
Yes, 67, what is this?
No. In this case, I am for the opposite party too, my lord. May I please, your lordship? Lordship, I am for adjournment. Yes.
Adjournment. Yes.
60? 70.
70.
May I please?
Yes.
Item 70 to 1 week after.
Adjourn. Yes.
71. 71.
None appears in the interest of justice adjourn. May.
73.
My lord, on the last question, on the last, my lord, director will take the, my lord, instruction, whether chemical examination as report has been, my lord, submitted in the next time or not.
Yes.
But regarding that, my lord, we take instruction. That instruction has not come.
We are going to cross of the case is that not, but within the statutory period, the IO is unable to file the FSL report with the genesis basis of the integral part of the.
That's pending in Supreme Court now.
Well, that we can the availability to the petitioner is only 167 the default well. But where the
let us know whether it has come or not. He has to give next week.
My lord is correct that my lord, he has to file also the petition that 167
that was rejected.
That has not been filed. Whether that has been filed as per the that Ravindran case, that has to be filed, my lord, immediately. Whether that has been filed in time or not, that has to be said. That petition has not been annexed. And my lord,
you seek instruction. I am putting it in next week.
Yes.
Because here I have filed the written note of submission.
See, written note of submission filed by the opposite party member, filed by Mr. Swani, is taken on record and copy is supplied to this.
Yes.
You just see it accordingly will do.
Yes, here Supreme has also dealt with and it was referred to larger bench. Supreme has already lordship granted.
Next week.
The larger bench is pending. That is pending.
Yes. Larger bench has already.
You take the bunch and see.
Yes.
Address and so that we can decide this way. Okay.
Next week,
next week. Then?
Monday,
not Monday, Tuesday, Wednesday.
14.
I'll come one. Yes.
70 sir, adjourn.
71
ଟା ବି adjourn.
ଏମିତି ହଇରାଣ କରୁଛୁ ନା କହୁଛୁ ନାହିଁ
70 ଟା ଛାଡିକି ଯାଉଛି ପଳେଇବ 72 ଟା ଛାଡିକି ଯାଉଛି
ରିସିଭ୍ କର ରଖ
73 ଟା adjourn
ରିସିଭ୍ କର ରଖ
ସୁଜୟ ବୋଲୋ ଏଟା 10 ଲକ୍ଷ ଦେବ ଏଟା ଗୋଟେ ତାର ମାଗି ଦଉଛ
71 ଟା
ରିପୋର୍ଟ ଇନ୍ ଦ ମେଲ୍ ଫାଇନାଲ ଇଟ୍ it's now one so that we very fast
hey chemical report with permission of the court of the
ଆଉ ତମର କିଛି ନାହିଁ
1 year ଭିତରେ ଦେଖିବା